Good morning, everybody. There we go. We're waiting for one more of the committee members. We'll give them another couple minutes, and then we'll get started. Well, good morning, everybody. Representative Turcotte, I'll be chairing this subcommittee work session on HB 1210. It's actually a culmination of HB 1210, 1351, and 1358. We'll speak a little bit more of that once we get into it. First, I'd like to have the clerk take the roll call, please.
Representative Turcotte.
Here.
Avalani. Huff, I'm here. Representative Sullivan. And Representative Bouchard. Representative Avalani.
We'll assume that's a here. We were just taking the roll. Okay. As I said, we had three bills that were all related to vaccines in the workplace, 1358, 1210, and 1351. So what we did is the subcommittee was formed, and I had the three prime sponsors of the bills pretty much get together with a few of us occasionally and attempt to come up with an amendment that would encompass what we thought, or what the sponsors thought, were taking the good out of them and releasing some of the bad in them. So what came out of that was Amendment 2022-0724H. Representative Lang, I'm going to have him speak to it. He did the majority of the work on it. So, Representative Lang.
Thank you, Mr. Chairman, Representative Turcotte. So on this amendment, we took those three bills. We found segments of the bills that we all thought worked well. The first of which is the general findings section, just making a statement of fact about the general what we believe is a general court. In speaking with both OLS, this is like the fifth draft of this amendment. As we were working with everybody. In speaking with OLS, we felt it was important to separate out the business aspect from the educational aspect and put the business and labor law and the labor law statutes and put the educational laws in the educational statutes, rather than do it as one simple, one bill that encompasses both in a single paragraph. So you'll see we brought out in 275-78, we talk about the exemption from vaccine mandates, public and private employers. We changed this to talk about only businesses that take federal or state funds is the first thing. We set a qualifier, so it doesn't apply to all businesses. That if you have a private business, it's 100% private, doesn't have any governmental interaction other than paying taxes, then they would not be subject to this law. If they take federal money or take state money in any way, shape, or form, then they would be subject to this new rule. And the rule does the same thing as we talked about before. It creates the law creates a simple form, allowing the employee or student in the second half of the bill to choose that they fall within one of three categories. And then on the employer side, we made a significant change, where before we had, we talked about reasonable accommodations, and that's a standard practice in business that they do even currently now. We said that in the original amendment, we talked about the word will, where it says the employer on line 22 of the first page, the employer, it now says may then work with an employee, and we had will originally, kind of like a forced mandate on the business, and we chose not to do that. We chose to back that off and change it to may. So if there's a way for the employer to work with the employee, we want to see them do that if possible. There may be certain terms and certain circumstances where that's not possible. And so we left that provision to the business. We created a separability clause, so if anything in this section 3 of the bill on page 1, that if any portion of this law is deemed unconstitutional, then only that segment of the law is strict, not the entire law. And then we do the same thing. We go into the education statutes, and we have the same exact terms and conditions. Again, if it's a school that takes federal or state money, and then we have the same process for the student submitting a request for an exemption in post-secondary education. I think this is, again, I worked with the prime sponsors. I worked with several members. I thought this was a reasonable amendment to kind of consolidate everything down. It's a real delicate balancing act trying to protect the business right to do business and protect the citizen's right to be a citizen and not be imposed upon unreasonably. And so I think this bill does that, balances those two rights, so to speak. And I'm happy to take any questions.
Thank you, Representative Lang. Do we have any questions from the committee? Representative Sullivan.
Thank you. Representative Lang, you pointed out the statement in line 22, the employer may then work with the employee to see if an agreement for a reasonable accommodation can be reached. Two questions. What do you envision as being a reasonable accommodation in this situation? And two, if the accommodation cannot be reached, what happens?
Sure. Thank you for your question. And what I'll say is that this is current business practice already. So they do this already. Prior to COVID and the politicization of COVID and everything, businesses routinely dealt with exemption requests. So I'll give you an example. As I'm subject to a vaccine mandate. I didn't want to give my data to my business. So I told them that. I said, I'm not telling you my vaccine status. It's none of your business. I said, but I'm willing to accept accommodation, and you can treat me as if I'm unvaccinated, regardless of what my status is. And my business chose to ask me to test whenever I go into the office, if I'm going to be around other fellow employees, or I'm going to be backstage because I happen to work in a concert field. And I felt that was a reasonable accommodation. I said, I'll accept that because my infection status is more important than my vaccine status. So in this case, I chose to accept that accommodation. I felt it was reasonable. They have a significant business interest that I recognized, and I felt that my accepting the testing was a reasonable response. So there may be other circumstances, and again, I'll go back to what I said in the public hearing on this bill. We use in nursing, right, which is where this most often comes up, in a cancer ward, right? I think it may be, and I'm not saying it is, because I don't know all the case law behind it, but it may be reasonable for a hospital to say there are no accommodations that you can make that could reduce the risk significantly enough to protect our cancer patients. So therefore, if you refuse to get vaccinated, then we're going to move you into a different ward. You cannot work in oncology. That may be a reasonable. I don't know if it is, again, but I could understand why a hospital may want to make that statement and be allowed, and then it's up for them to defend that. If the employee says that's unreasonable, and they can file a wrongful termination suit. But again, I think that's, again, current law. This is currently what's happening already. I mean, when I say current law, it's current practice in businesses. We're just putting it into law to make sure that it's clear.
Follow up?
So I think I heard you say wrongful terminations. So I believe that implies that if the employer and the employee cannot agree on an accommodation, then the employee would likely be terminated.
The employer has the right to terminate, or the employee has the right to quit, either one.
Thank you.
Any other questions from the Representative Bouchard?
Thank you. Thank you for taking my question. I'm pretty clear about what a medical exemption is, a religious exemption is. Could you define to me what the right of conscience exemption is?
My most favorite question I get asked right now, most recently. So the right of conscience is a moral objection. So I'm going to give you an example, and it's not off topic, so to speak, but I found it when I was researching bills on it like this, is that doctors enjoy the right of conscience when it comes to abortion. A doctor can refuse to perform a procedure and is protected by federal law if they declare a right of conscience that they find it morally objectionable to perform an abortion, and they cannot be discriminated against if they do that. So there's an example of a moral belief that someone may have that gives them the right not to do something. So I don't think it's any more, if we're going to enjoin and give doctors that right of conscience and say that they can choose what is morally repugnant to them and don't want to do it and not be discriminated against, we should be able to give our citizens that same exact right.
Follow-up?
Follow-up, Representative.
How could you relate a right of conscience to for a vaccination?
How do I relate the two?
Yes.
Sure. So if I think it's morally wrong to inject myself with a chemical, right? I believe it hurts my body in some way, shape, or form, and that's my moral belief, then why should I be forced to do that? If there's a body of evidence, around that there are implications of vaccinations to people. They may be minimal, it may be small, it may be infinitesimal. But if a person honestly believes that they've made the decision not to inject those kind of chemicals into their body, and usually it can be from birth. I know families that none of their kids have ever been vaccinated because the parents believe that it's not a good thing. That's their moral belief. Are we going to judge them on their moral belief for that and tell them that they're not entitled to their moral beliefs?
Thank you.
Could you guys turn off your mics? Representative Avalani.
Thank you, Mr. Chairman. Thank you, Representative Lang. Just a question on the grant portion in paragraph 1, line 13 to 18. We had last year before, we had the Main Street grants sent out by the state to businesses that were affected by the COVID-19 shutdown. Does that make them public employers if they receive those grants?
I'm sorry, if I heard your question right, if they received any COVID funds, would they be considered a public employer? Is that what your question?
Correct.
I'm going to say yes.
Any other questions from the committee? Representative Sullivan.
Just to follow up to what Representative Avalani was just saying, so a restaurant that receives COVID funds as well would be covered by this bill, correct?
That would be my interpretation, yes. Any business that received federal funds, a business that chose not to receive federal funds would not be subject to this bill.
I have one question, Representative Lang. Back to the conscientious question that was asked, the right of conscience. Would it be fair to say that we talked about it's a moral issue? Would it be fair to say that the right of conscience is similar to the religious exception without the tag of religion?
Thank you, Mr. Chair, and I'd say that's exactly correct. I would say probably the majority of the people that currently fall underneath the right of conscience are using the religious exemptions anyway, so I don't think it's a necessarily significant number that we're talking about that would differentiate.
Thank you. Are there any other questions for Representative Lang? Representative Sullivan again.
Yep. The other difference, when you look at the religious exemption and the medical exemption, in adding the conscientious objection exemption, the other difference, however, is that all they have to do is say, I object, and there's no further questions, no further justification, no further explanation. Is that correct?
If this amendment is adopted on all three circumstances, again, this comes back to the question of whether or not you think it's appropriate for businesses to ask for medical data, even though they're not asking for, they're not asking for necessarily an accommodation. They're not saying, I want you to change my work habits because I have this medical condition. It's not a, for lack of a better phrase, I'm going to say a true ADA requirement. On religion, it's even easier. Is that, do we really want our businesses or you having to say, tell them what religion you are, what tenet of your faith is, and then have them check to see whether or not you're religious enough to be entitled to the exemption. So in all of these, I don't think we should be checking. We self-attest to more things in our society on almost everything. When you go into motor vehicle, you give them a driver's license, you give them a birth certificate and some other form of ID, a social security card, neither one of which has your picture on it, and you sign a form saying this is who I am. Right? We regularly self-attest with some basic information and in society. When you register your kid for school, I actually don't have to show a driver's license to register my kid to prove who I am. So we regularly believe and take on faith within the government our citizens' answers to things, and I don't think this should be any different.
Follow up?
However, at present, it is different, and an employer is entitled to ask for backup information about the medical or the religious exemption, correct?
That is correct. And again, one of the reasons this bill came forward is and I spoke about this, I believe in my original testimony, was on 9/12 of 2001, the attorney, the Surgeon General of the United States said that he was going to start checking into employers, employees, whether or not they were abusing the religious exemption. And if that doesn't take a bone-chilling effect about the fact that a senior member of our government is saying we're going to start measuring our citizens' spirituality, I don't know what is. Government has no business in my religion.
Any other questions? You can? You have a question?
I do.
Oh.
As a member of the committee, not the subcommittee, but as a member of the committee.
You can? Oh, I've never done this, so I'm just making sure. Somebody else told,
I caution the chair.
Mr. Chairman,
Yeah.
Mr. Chairman, my opinion of a subcommittee is usually what you're doing now.
Okay.
The subcommittee has their debate, they discuss it.
Okay.
Questions are asked of the subcommittee, of the sponsor. The subcommittee can then ask questions of any particular person out there, whether it be a lobbyist or the department, and then.
that would be my assumption, only I was told something differently by our administrator, Ms. Goley, said something different, but that's fine. Go ahead.
I think each chairman of the subcommittee can act as.
Representative Infantine.
I have two questions, one of which I just want to follow the bouncing ball here regarding something you said. Because I want to make sure you use the right term. You mentioned a situation where someone chooses to be any of these three reasons they want to not take the vaccine. They tell their employer, the employer will endeavor to provide some kind of accommodation. If accommodation cannot be made, you then said, I believe you said, then they could file suit. I believe the procedure it is now and the procedure you're continuing to go with is if they cannot get an accommodation, they can either quit, they can contest to the Department of Labor. The Department of Labor then investigates looking at whether the accommodations that were offered are consistent with past practice. If they are consistent with past practice, then it would be fine, no problem. If not, then the Department of Labor could then step in and say, no, that's inconsistent with past practice. And then whatever, either force the employer to be more consistent or then find against the employer. Is that your understanding of the way it is?
That is my understanding.
Follow up, please, Mr. Chairman.
Follow up?
The only thing that concerns me that's not been brought up thus far is all these fear-mongering emails and calls I've received in the last 3 days that because this does not fit some federal guideline, hundreds of millions of dollars from nursing homes, whether it be the county nursing homes, private nursing homes, hospitals associated with getting Medicare and Medicaid. This will interfere with that and negate that, and they will no longer be able to receive those monies.
Thank you for the question. I can tell you that this is a similar concern that was brought up in the Florida when they amended their exemption statutes, and to date, CMS has done nothing. The government is not acting on this. They recognize that exemptions are allowed. Probably the biggest concern in this bill is the fact that we've added the right of conscience. Compared to, other than that, this bill would conform with all of the CMS rules. The right of conscience is, though, in New Hampshire has been extremely, like I said in my testimony, has been called out very explicitly as unalienable, that our citizens have the right. And I'll be honest with you, I'll be happy to remove the right of conscience in this bill if someone could tell me how I can unvaccinate myself.
Thank
Any
you.
other questions from the committee? Representative Lang, I'm going to make kind of a comment, and speaking to the importance of in line 22, the may versus will. I mean, I can give you, much like yourself, I've been directly affected by the whole vaccine mandate situation. I can certainly see examples of where may is much more beneficial than will, only because there may actually be some businesses out there that want to be able to point to this and go, right of conscience, right of conscience. I'm going to give you the exact example myself, okay? Initially, last fall, pilots at American Airlines and all of the major airlines fell under the mandate that President Biden put down on federal contractors, okay? We received an email from our chief pilot saying you have such and such amount of time to get vaccinated, otherwise you're going to be terminated for myself after 37 years of service. Long story short, our company did not in the least want to eliminate 20% of their workforce pilots. You're not going to be able to run an airline when you get rid of 2,500 pilots out of 14,000. So this, to me, when I look at this would be American Airlines management going, now we don't have to fire our pilots. We don't want to require them to get the vaccine. The feds are telling us this, but here we get the right of conscience. And I'm just using my airline as an example. This could apply to different businesses, but would you see that as a fair point?
I do, an extremely fair point. Again, I look, to use one of the governor's favorite words, flex, right? This allows businesses to flex and manage their business how they choose to manage it. We're not putting in that ability to work, or to choose to work if they need to, but they also may say there's no accommodation necessary. We don't need to do anything. You're fine.
Exactly.
And so this allows for that in either direction. You can either choose to let's work with you and find an accommodation, or after reviewing and your thing you're a home-based employee. There's no accommodation necessary, so just continue working at home. We don't need you to do anything. So again, I think that this is a flexibility bill. It allows the flexibility for businesses to be able to operate. And I think it's, again, it's a great balancing act between the rights of the citizens and the rights of the businesses.
Thank you. Any other questions from committee members? Representative Huff?
Thank you, Mr. Chair, and thank you, Representative Lang. And this is just for clarification for myself. It says on line 17, shall offer the employee the opportunity to submit. It doesn't say shall accept. So what I'm driving at here is that this says that they will have to have the employee know that they can give an exemption request, and the exemption request would come in, and it says that they may decide to work with an agreement, but the employer is under no obligation at all to.
So I'd have you take a look at line 21 under section 2, where it says such request for exemption shall be granted.
Oh, okay.
And then we go into the may.
I withdraw my question. Thank you.
Representative Lang, would you be willing to take questions from anybody out there if they have them?
Absolutely, Mr. Chairman.
And I don't know, Deputy Commissioner Ogden, would you like to come up to the mic, make some comments, and then we'll open if Anybody else in the gallery has questions, we'll open it up.
Thank you, Representative Turcotte, and thank you, Representative Lang. In terms of questions, the only thing I would provide is just some general commentary specific to some of what we've heard today. I would just want to point out relative to Representative Avalani's question about receiving funding. Absent additional clarification, we, the department, would look at lines 13 and 14 where it says any public or private employer that receives public funds. We would look at it as something of an ongoing, that there is a receipt of public funds. If the intent is to say that had they ever received public funds, they would fall under this umbrella, I think perhaps that should be clarified. Representative Infantine had made the comment about reasonable accommodation or reviewing the reasonableness of accommodations. I do want to be clear that the New Hampshire Department of Labor does not typically engage in that type of analysis, specifically when we're talking about reasonable accommodations. Most often, I think most folks understand it coming up in the context of ADA requests or things of that nature. That's all under federal purview, so I just want to be clear that that type of analysis does not typically fall with us. Saying that, in practice, I believe how the Department of Labor in New Hampshire would interpret and apply this law would be mainly that we see that there is now a requirement that if someone files one of these forms, it shall be granted. It then does say that the parties can work together. We would be looking to say, okay, it's reasonable if the parties have agreed to that, because again, the text of the provided legislation says that the employer may then work with the employee to see if an agreement for a reasonable accommodation can be reached. Essentially, I will tell you in practice, I think what we would do is we would say, did the parties come to an agreement? If they came to an agreement, that works. If they didn't come to an agreement and it led to termination, we would then probably look at that and say, okay, the exemption was then not fully or granted in some form. And I don't know if we're misinterpreting what you're trying to do here. We would look at this as saying, employers requiring this, exemption shall be granted, meaning they should not require it. They can then try to work to some type of accommodation. If they work to the accommodation and agree to it, fine. If they don't, and then the person was terminated, and someone then complained to us, we would likely look and say, okay, exemption not granted, employer, you should grant that exemption. They would get 30 days because sitting in 275, this would be under our general penalty powers. So there'd be 30 days for the employer to correct it. And namely, correction, I imagine, would be saying you should have granted the exemption in both, form and, actually do it. If they don't do it then, after the warning period expires, the 30 days, we would be able to impose a penalty of up to $2,500. I see it as more of a deterrence factor than anything, is we would say you're supposed to do this. If you don't do this, you should be penalized. The only other thing I would point out is this does not clearly give us job restoration authority. When it was talked about wrongful terminations and things of that nature, that's not something that comes to us or is administered by us. So I just want to be clear that the department's application of this law would most likely be in the form of deterrence, saying you should be granting this. If you're not granting this, you could be penalized. So I'm happy to take questions, and as you guys know, it's not us putting forth policy or in any way trying to advise what should be done. I just want to be clear that's how we would interpret or apply this. And I wanted to be very clear on that reasonable accommodation. That's not analysis we do, so we would be looking, did the parties come to an agreement or not? So I'm happy to take any questions.
Thank you. Anybody on the committee? Representative Avalani?
Thank you, Mr. Chairman. Thank you, Deputy Commissioner Ogden. Line 13 was an issue, and I'm glad you brought it up. Would you make a recommendation of a change that would clarify an ongoing use of public funds for daily operations, or a one-time, or a segmented, or relief funds, or something like that? How would you differentiate between the two so that a one-time grant to a place of business, that they don't automatically become a public employer?
Again, I think there should perhaps be clarity in terms of if you're looking for one-time recipients to fall under this. I think you would want it to say something akin to receives or has ever received. If you want it to be an ongoing thing, it should probably be clarified to say something to the effect of regularly receives or receives on a schedule basis or something of that nature. I apologize, I don't have the words immediately in mind, but I would just suggest that you do perhaps look to clarify that, depending upon what the intent is. I don't know what the clear intent is there, if it's ever or ongoing.
Thank you, Mr. Chairman. Thank you, Deputy Commissioner.
One question on that, the ongoing versus one time. Other than, can you think of any instances other than recently with the COVID pandemic? Are there any other instances you can think of where there have been one-time mass influxes of capital to businesses?
Not off the top of my head, but looking at the language here where it talks about federal contracts, I guess one way to look, if they ever had done a federal contract or had ever touched it. But I'm not, I think COVID is unique in the sense of, I think all of a sudden there were a lot of businesses receiving an influx, but I can't think of many other examples.
So the issue there is maybe, okay, thank you. Any other questions? No? Thank you,
Thank you.
Commissioner Ogden, Deputy Commissioner Ogden. Are there any questions from the gallery for Representative Lang? Come on up.
Good morning, Mr. Chairman, members of the committee. For the record, Paula Minahan, Senior Vice President, State Government Relations for the New Hampshire Hospital Association. We testified in opposition to the original bill, and we remain opposed to this bill, and I will outline for you why, how important our Medicaid and Medicare funding is, and that, in fact, it would be in jeopardy if this bill were to pass. It is in direct violation of the CMS requirements. I am happy to share with you some documents from CMS, but I know it's been challenged and questioned, not only in this committee, but other committees, relative to whether or not federal funding would be in violation. And I am happy to share with you, but it's one FAQ, which I think is very informative, and I'm happy to share it with you. How will this new requirement, which is the vaccine requirement, be enforced? Then they talk about state surveys, which are, it's a very significant process that state surveyors, in our case, it's under health facilities, that they would be surveying for compliance of nursing homes, not only private, but also county nursing homes, as well as New Hampshire Hospital and all hospitals and anyone that's actually, any facility that falls under health facilities. How do the penalties work? Medicare and Medicaid certified facilities are expected to comply with all regulatory requirements, and CMS has a variety of established enforcement remedies. For nursing homes, home health agencies, hospice, this would include civil monetary penalties, denial of payment, and even termination from the Medicare and Medicaid program as a final measure. The remedy for noncompliance among hospitals and certain other acute and continuing care providers is termination. However, CMS' goal is to bring healthcare facilities into compliance. Termination would generally occur only after providing a facility with the opportunity to make corrections and come into compliance. That answers the question about Florida. I've heard that numerous times in numerous committees. Florida has a law that is in direct conflict with CMS federal requirements. And the reason probably nothing has happened, it's either the facilities are already following the CMS requirements, and or they're just, CMS has not gone into those facilities in Florida. But I would contend that that is not something that New Hampshire wants to actually challenge, because that would put our hospitals in direct conflict, and then you have this issue with what the other question that continually comes up is, well, New Hampshire law would supersede federal law. According to CMS, the answer is quite different. What happens if state law prohibits vaccine mandates? How can CMS expect a facility to follow its requirements if the state prevails prevents them, from implementing this rule. Under the Supremacy Clause of the U.S. Constitution, this regulation preempts any state law to the contrary. So that is directly from CMS. In addition, conscientious objection, and I will direct you to a letter, and I know David Juve from the BIA is here, so I'm not going to speak for him, but he wrote a very compelling letter dated February 10th to this committee relative to conscientious objection and why it is not it should not be included relative to this vaccine vaccine exemptions. The hospitals, and I obviously represent hospitals, so hospitals have routinely and have for a long time allowed for medical and religious exemptions. The right of conscience is not contemplated, never has been, and continues not to be, and CMS does not allow for that. Conscientious objection, as the BIA letter indicates, is not contemplated. So that's another CMS violation. The other part where you allow for a simple, submit a request, which is, as Representative Lang said, very simple. The hospitals must have policies relative to medical and religious exemptions, have forever. They've required flu vaccines and other vaccines, as I think my testimony in prior hearings have stated. They have a policy. They have a very significant process that they go through for reviewing every medical and religious exemption. So again, that line 20, just submitting a request and stating that you have a conscientious objection effectively nullifies the entire vaccine requirement. Because again, that is not, you raise your hand and you say, I object. That is not contemplated by CMS. So the hospitals cannot meet that requirement. The shall, again, you cannot have a review and actually render a fair and reasonable review and process for the employee. You just it shall be granted. And then the accommodations, I've heard this is stated for that it's current business practice, but I would contend that you can't just reallocate resources, if you will, if an ICU nurse is unwilling to follow this and indicates they want an accommodation. There are very important considerations relative to patients and their vulnerabilities. I don't care if you are an ICU patient or if you're a podiatry patient. If you have underlying health conditions, you are at risk. And our hospitals have contend that is not a risk that they are willing to take. So that is why they have put in this policy. I mean, it's restated again, as Representative Lang said, under the education relative to students. And I know there are others in the audience that actually teach nursing students, so perhaps it would be best to have them speak to this. But it is our understanding that the nursing programs, they have really not had a problem relative to ensuring that those that go into a hospital for a rotation are following the requirements of that institution. And again, everyone that's then again, it's CMS requirement, volunteers, contractors, employees, unless you're 100% remote, must follow the CMS mandate. And when you have a student come in for a rotation in a hospital, they are rotating throughout every department, including labor and delivery. So again, unwilling, the hospitals are unwilling and will not put those patients and certainly those unvaccinated newborns in harm's way. I think that's it for my comments. Happy to answer any questions.
Thank you. Anybody have any questions? Representative Sutherland.
This bill does not specifically address COVID. It more generally addresses vaccines.
You're right.
Can you tell us how big a problem it would be if someone refused to take any vaccinations whatsoever?
That is a very astute astute point, and you're right, it's any vaccine. So again, currently, hospitals, and I probably have it in my testimony, there's a whole list of vaccinations, inoculations that are required. I don't think it's in this testimony, but it was in another testimony. There's, and again, there's a nurse sitting in the audience. She knows, Pam DiNapoli, I think, can cite those. But there are a whole list of vaccinations that are required as a condition of employment pre-COVID and continues to be. You're right, those are also would be in jeopardy if this were to pass. Thank you for your question.
Representative Lang?
Thank you. If I could ask a question, because I'm looking at this
Absolutely.
bill, and we're looking at potential, using this as a basis of maybe mending, so having an input's important. So I guess my question is, my intent of this bill, with the exception of the new add of right of conscience, was to put into law basically current procedure. It's my understanding currently that hospitals do allow for both medical and religious exemptions, and they do, if there is a possibility of accommodations, grant accommodations. Is that not accurate?
That is accurate. The
So that-
conscientious objection is the problem.
So that's the only problem you have in here is the right of conscience, that issue of adding the right of conscience? Is that?
So that is, again, one violation. That would be in direct contradiction with CMS. So the right of conscience is definitely an issue. The written request shall simply state, like I said, the policy is otherwise. There is a form and there's a process. There's a policy and a process. So that makes it a little less. And again, this is also CMS indicates this. And then it says, such request for exemption shall. It doesn't say may. It says shall. Again, if you follow this, each word, that indicates that it doesn't matter what the process is, that it shall be granted. If you sign a piece of paper, it shall be granted. That's the way I read it. Maybe that's not your intent, but that's the way I read it.
So if I can follow up something,
Oh.
I'm trying to figure out how I might reword this to make it more palatable for people. So again, if anything, what this law would do is simplify the process rather than complicate the process, in that you would not have to investigate medical exemption requests. You wouldn't have to investigate religious. You don't have to find out what a person's religion is, what tenet of their faith is it that requires them not to get the vaccine. You don't have to look at past practices of the patient, of the worker.
Mm-hmm.
So this would simplify that process dramatically for the business, would it not?
I think it would actually make it more challenging because again, what's the point if there is no due process? The employer owes that employee due process. If you just say, I want a medical exemption and that shall be granted, that exemption, there is no process. So that's the problem. I understand what your concerns are, but again, CMS requirements actually do require that you document it because, again, the surveyors, remember, the hospitals are under CMS survey, and they have to be ready at all times. So health facilities comes in, and this is a survey requirement. They say, what is your policy? You have to give it to them, and show me what the process has been. Have you treated employees fairly? Have you given them that due process? And if you did what is outlined in this, I appreciate that it would be simpler. It just wouldn't be it would not be surveyable, if that's even a word. The surveyor could not check the box and say, you met the CMS requirements. You're now in jeopardy. Your conditions of participation in Medicare and Medicaid are in jeopardy. They could cite you, and then, again, the process, as I outlined, would start. I know, I heard Representative Infantine say fear-mongering. It's not. This is serious. 60 to 80% of hospitals' reimbursement is Medicare and Medicaid. 60 to 80%. They would lose their federal and state funding. This is not fear-mongering. I promise you it's not. This is serious. And that's why the administration went to the Supreme Court and asked for a ruling so that it could be clear. I also hear from other legislators that don't think that that is the final word, but it is. It's the Supreme Court, and no other lower court is going into appealing that. It is, CMS mandate is being implemented. It's just being implemented now. That's why we're not hearing from, I think the first state is probably Florida. But we should not, we should not put our hospitals in that kind of jeopardy. We should not.
All yours.
Thank you, Mr. Chairman. Question for you about, I think, we heard from Mr. Lavers on the unemployment section a little while ago, this committee did, about healthcare workers where their exception was granted, but their employer made the determination that no accommodation was possible given the nature of their work. Do you see this bill changing that in any way, that balancing could still be made where you acknowledge their exemption and grant it, but still have to make the determination of whether an accommodation is possible under the circumstances of their employment?
I am not sure that I am remembering the same testimony from Mr. Lavers, but I believe Employment Security was talking about those that were not granted an exemption and went to Employment Security looking for unemployment benefits. And his statistics indicated that, I can't remember, I have it written down somewhere, that out of 90, 80 were upheld or whatever. I shouldn't even state the stats. But that was my understanding, is they were challenged. They wanted unemployment benefits because they left employment because their exemption was not granted. I'm not, but I apologize. I think might be remembering a different testimony. I'm not sure.
Follow-up?
Representative follow
Thank you. Actually, it was the inverse of that. I think it was something like 90% were denied, and I think you're talking about that 90% was denied. I think but the 10% that were granted, I believe, were employers that acknowledged and accepted either the medical or religious exemption as valid, but then found due to the circumstances of their employment, there was no possible way to accommodate them in the situation. And that was the minority that was, their unemployment was granted and paid.
Oh, okay. Thank you. Thank you for
And
clarifying.
that's the group I was asking about.
Okay.
And whether this would change any existing practice, because I think it would put, it would short circuit the first step where the exception and the exemption would be acknowledged as granted. But I don't think that the intent of this bill is to short circuit that secondary investigation of whether an accommodation is possible given the circumstances of the work. And I was wondering whether you saw it differently than what I just said or not.
I guess I would question if this is current law, why do we need this? Because if the employer may then work with the employee to see if an agreement for a reasonable accommodation can be reached. And like you said, I think that's what they try to do if the exemption is granted and then they try to accommodate. Or, yeah. So that, like you said, that minority piece. Probably a good idea to have Mr. Lavers come back and talk about that. But again, if they're already making accommodations, so I'm not sure why we would need that stated in law, I guess.
Thank you. Representative Bouchard?
Thank you for answering.
Of
the
course.
question. When you read this bill, do you interpret it that anybody can walk in, an employee, to the employer and say, I do not want to be vaccinated, and it's because of religion or medical or conscientious, and then you have to grant it?
Yes,
how you interpret
yes,
this bill?
Representative Bouchard, that's how I interpret it. It is an automatic, because of the shall be granted, and this is, of course, if they require a vaccination requirement. And, yes.
Okay, so just a follow-up,
Mhm.
please. How is that different from what's happening now?
So the hospitals have a requirement. They imposed the requirement starting in August, long before the federal government came down with their CMS requirement. So they determined that based on the safety of patients and their employees, and because of the nature of the work that they do, that they needed to impose these vaccination requirements for COVID. Before that, again, there's a whole litany of other employment-related vaccinations that hospitals have imposed for years. Flu vaccine is the most common, but there are a whole bunch of them, MMR and a whole bunch of there's a list. I have it written, and I'm happy to share it with you. So they require it, and if someone were to say, I cannot get the flu vaccine because I'm allergic to what's in the flu vaccine, for instance, so they would request a medical exemption. And there's a policy, a written policy, and then you fill out a form, and then it goes to a committee with clinicians at the hospital, and they review that, and it's a signed document from the patient's physician or provider stating why they cannot have the flu vaccine. Then that's reviewed, and if it's accommodated, then if it's accepted, then the accommodation may be full PPE. Prior to COVID, we weren't all wearing masks, but the hospitals during flu season, they certainly do. But they might have to wear additional protection because of the, how highly contagious the flu virus is. So that's what would happen. They would make an accommodation like that. So during flu season, you must wear a mask or other PPE if you are not able to get the flu vaccine. Did I answer your question?
You did, thank you very
Okay,
much.
you're welcome.
Thank you. I have a series of questions for you.
Sure.
The last one the comment you made, I think actually plays to what Representative Lang's trying to do here. You just said that reasonable accommodation is made for the flu on an annual basis by requiring the individual to wear a mask or some other thing. I mean, unfortunately, some of my other comments go to COVID versus everything else we've ever dealt with. And the reason we're seeing a lot of this stuff is because of that. First question, well, let's start from the back forward. You mentioned when we were talking about the conscientious objection versus religious. I'm going to give you an example. Representative Huff here, we work for the same company, doesn't matter what it is. He submits
I'm
a
listening,
religious, he submits a religious exemption, and I submit a conscientious objector, or whatever the wording is in here, because I can't truthfully put forward a religious exemption. What is the difference net outcome between when he is granted his exemption and I'm not in your not in the nursing or hospital or that, but in general, what's the net effect? Is there any difference in the outcome of Representative Huff and myself? Am I
So
saying
the
that correctly?
policy right now, again, I can't speak for other employers, but for hospitals, they allow for medical and religious exemptions. So you go through the process, and then Representative Huff's religious exemption would be considered by the committee and either granted or not granted, and then that's communicated.
Let's get way beyond that. We've
So-
already gotten through all of this. He's got his
He's-
exemption.
okay.
I've got mine. Is there any difference in how either one of us are going to be handled?
The conscientious objection is not on the list, if you will.
I understand that. I'm saying under this bill,
Oh.
if it passes, what is going to be the difference between how he is handled and I'm handled?
The hospital would be in direct violation of
Not-
CM.
I'm not, I'm trying to get it away from the hospital scene, because this.
But I
this-
represent hospitals, so,
understand.
so maybe it'd be better for David Juve to
Somebody else,
answer.
okay. Let's go back to the very beginning. You were reading some FAQs
Yep.
from CMS. What date were those put out?
They were put out, they were updated, hold on, and again, I'm happy to send this. They were new, some of them were new in January 20th, 2022. They were new a couple weeks ago.
The ones that you
Updated.
read were new on the 22nd?
They were initially issued on November 5th, 2021, and have been updated as of January 20th, 2022.
Okay, thank you.
And the title is FAQ, you could actually look this up if you wanted and Googled it. CMS Omnibus COVID-19 Healthcare Staff Vaccination Interim Final Rule. And it's the external FAQs, and it's 15 pages long. Again, I'm happy to send this, but I didn't want to bog you down.
Thank you. What percentage of your hospital workers or the people you represent took the jab voluntarily? How many resigned because they refused, and what percent were actually terminated?
I don't have those numbers right in front of me, but I would say,
Approximate?
well, the hospitals aren't required to report that. So we just have anecdotal information, but some have actually come out. Dartmouth Hitchcock did a press release that they had well over 95% of their employees are vaccinated or have received an exemption. I can try and get some of that information. It's completely anecdotal. Nothing is required to be submitted. And then employment security, as Representative Prout was saying, Mr. Lavers, I think, is best to answer the question about those that were fired and or were let go and then went to employment security and went through that process. So I don't have those actual numbers, but I can see what I can get. But what has been reported by hospitals is well over 95% of their employees, actually higher than 95 plus are either fully vaccinated or have met an exemption.
I understand that number, but that doesn't really get to the heart of what I'm trying to get at, and that is how many took it voluntarily and said, yay, I want to take this jab. How many were forced to take it under threat of losing their jobs, and how many were actually terminated because they refused. Again, I'll use my company as an example. We started off with about 25% of our pilots who said, I'm not going to do it. President Biden put in his federal contractor mandate, and under the threat of termination, a lot of them ended up getting it. Our company can now come out and say, with the same statistics you just said, 95% of our company has either received an exemption or has had the vaccine. 5% of us have done nothing. We didn't request, we didn't get the vaccine. So, but that number, the 95%, does not speak to how many did it only under the threat of losing their job. And I can tell you in terms of the pilots, it was probably, I don't know, 1,500 under the threat of their job. And we can go into anecdotals of how many of our pilots have passed away due to, immediately following the implementation of taking the vax. But so the numbers I'm looking for is how many people are actually saying, yay, I want to take this experimental drug where the
It's not experimental, but
with
I think
the-
we'll agree to disagree on that, but
that's
it's
fine.
not
We
experimental.
can disagree on that.
It's fully approved by the FDA. We don't have those numbers, Representative, so I don't know that I'll be able to satisfy your question. The vast majority of healthcare workers support the vaccination and willingly had that they chose to do it. They were not. They did it well before their employer ever imposed the requirement.
Okay, thank you. Any other questions?
Mr. Chair? I want to
Representative Lang.
restate one of your questions, and I think I can get the right answer. I think the question the chair was trying to get to earlier about accommodations was if you, assuming this law went into effect and you had to grant an exemption and create a reasonable accommodation for those three categories, whether it's medical, religious, or conscientious objector, would the accommodation be different based on the reason they chose the exemption, or is it?
That's a hypothetical that I can't answer because, again, that's not what the hospital's policy is now. So I don't know. Again, what's more relevant, I guess, I don't know if that's the right word, what's more concerning is that they would be in direct violation of CMS. That's CMS requirements. So they cannot make that accommodation
So-
without risk of losing federal funding. That's the concern.
One more follow-up. Let's
Oh.
go back to just the CMS rules then. So if you had a medical exemption, a religious exemption employee, and your goal is the safety of the patient in the hospital, you had said that they would be required to mask or wear full gown PPE, but that exemption, that accommodation wouldn't be different. You're giving the exemption because of they're not taking the vaccine, so therefore the accommodation should be the same, correct?
Perhaps, I don't know what the accommodation is, but if you're unvaccinated and you're treating patients, I would believe, again, the hospitals have policies and they do, they would have to make sure, again, that the patients are fully protected and other staff, so.
So I think what you said was that an unvaccinated person is treated the same as it relates to accommodations, regardless of the status, the reason of the unvaccination
As far
status.
as, I don't have specifics, but it certainly makes sense.
Thank you.
Representative Sullivan, did you have anything? No? Good. Anything else from Ms. Minahan? Thank you.
Thank you.
Anybody else in the audience like to talk? Okay. Yeah, come on up, and then David Juve will be next, and then whoever else. Can you turn on your mic, please?
Pam DiNapoli. I'm a nurse, and I taught at UNH for 20 years in the Department of Nursing, and now the executive director of the New Hampshire Nurses Association. And I understand this is a labor committee, but I think that you have to talk about human costs. And I think the representative's comment about this applies to all vaccines is really an important point. And the issue with conscientious objector is that it broadens the exemption. So anybody, and we've seen this over time. So we've seen what vaccines have done in terms of disease. So we have a period where within the last 10 years, there was a lot of disinformation about vaccines causing autism and other things. And there were more people requesting exemptions. And at that time, we saw an increase in communicable diseases. So we know that vaccines work. And we want to limit the number of people who can claim an exemption, because as we broaden it out, so now you don't need to have your MMR because you don't want it for your children. So now we have a measles outbreak in the city of Manchester. So then you have to figure out who's vaccinated and who's not vaccinated. So it puts the human cost of eliminating a vaccine requirement is huge to a community, to the healthcare profession, and to the population in general. So I just think that the problem with this bill is broadening the exemptions. And just remember that we're in a COVID time, so we're talking as if this is just about COVID. This is about human disease. And we know over time what vaccines have done to decrease communicable diseases. So I think this is a scary bill from a health perspective. And I think from a labor perspective, there's a lot of cost to human capital. So I just want you to consider that when you're thinking about the CMS costs. This is really human costs that we're talking about. And in terms of post-secondary education, none of our students cared whether or not they had to get the vaccine. They wanted their life to be back, so they line up for vaccines. All of our nursing students have had to have vaccines to come into the program for 20 years. So, you know, the whole issue that they're going to be that they don't want to take it, then that impacts their clinical experiences. And that's always been the case. So, and hospitals consider medical and religious exemptions very carefully. So everybody gets due process. So, I think that you don't want to open this up to raise your hand and say, I don't want a vaccine. It's a scary proposition.
Any questions? Thank you.
Mr. Chair, can I just make one comment?
Absolutely.
So, we talk a lot about the right of conscience, and again, I'm going to go back to, I'm literally on the hhs.gov federal website, and when it talks about healthcare providers and their right of conscience, is that specifically written right into the law under conscience and religious freedom. It says, conscience protections apply to healthcare providers who refuse to perform, accommodate, or assist with certain healthcare services on religious or moral grounds. Federal statutes protect healthcare providers' conscious rights to prohibit recipients of certain federal funds from discriminating against healthcare providers who refuse to participate in these services based on moral objections and religious beliefs. So we extend this right of conscience to healthcare providers, and we have these same healthcare providers refusing to extend those same privileges they have to our citizens, and I just find that hypocritical.
Thank you. Mr. Juve, how are you?
Thank you, Representative Turcotte, Mr. Chair, members of the subcommittee. For the record, my name's Dave Juve. I'm a Senior Vice President for Public Policy with the Business and Industry Association. We serve as New Hampshire's statewide Chamber of Commerce. We have over 400 employer members with over 80,000 employees in the state. I primarily just wanted to respond to some questions that came up that I felt there was still some vagueness as to the answer. And I'd like to start with Representative Lang. You were asking about reasonable accommodations and whether it would differ depending on the exemption that was being taken, if I am stating that correctly. My belief is it would not differ. A reasonable accommodation is either a verbal or written agreement between the employer and the employee and it relates directly to the employee's ability to do the job. So whether they chose a religious exemption or a medical exemption or this new conscientious objector exemption, I don't believe that would be a part of the discussion between the employer and the employee about their ability to do the job. Representative Turcotte, you were asking if, from a practical point of view or from the employer point of view, does it make any difference whether it's a medical exemption or a conscientious exemption? And I guess my response would be for some employers who are not...
Actually, it was conscientious versus religion.
Okay, yeah. Thank you for correcting me. For some employers, and I'm going to talk about employers who are not a part of the CMS mandate, because I do agree with Paula that those employers are under stricter rules than other employers. So I shouldn't say most, some employers, if a religious or medical exemption is requested or a new conscientious objection, if this bill is passed, they don't take it any further. They will just grant it. So in that case, there would be no difference. Other employers handle it differently, and there is a process, an in-house process, where they will try and evaluate that exemption being requested. The medical exemption is fairly straightforward. It's not 100% foolproof, but it's fairly straightforward. They check with, the individual's doctor, and, you can come to a pretty quick determination. A religious exemption is a little bit vaguer and a little bit more difficult for an employer to engage in a discussion on, because obviously it's a very personal part of an individual's life. However, some employers will ask for at least a conversation to take place. For example, what is it about your religious that would not allow you to feel like you could take a vaccine, and that individual would have to respond whatever the response is. So there is some level of discussion that takes place. I don't see how you could have any discussion about a conscientious objection other than I just want to make sure you have a conscientious objection. Yes, I do. Check mark it off. So there is a subtle difference between religious and conscientious objection discussions that take place for those employers that want to have the discussion. And then it seems like there might have been another question asked, but those are the two that are at my top of mind. But I'm happy to try and answer any other questions. I do want to emphasize, I guess I should also say that Representative Lang and myself and two very savvy, very experienced federal labor law attorneys had a conversation about this bill. It was cordial. I thought it was very respectful. But we did come to different conclusions about whether the federal government would recognize a conscientious objection exemption and whether the federal government requires some documentation on the part of the employer. We both believe we have the research to back up where we are at, but we differ on that opinion. In any event, I'm happy to try and answer any questions.
Representative Sullivan.
Thank you for taking my question. You described under the religious and medical exemptions the process that employers go through.
That some employers go through.
Would you agree that under the language of this bill, those procedures would be eliminated because all they have to do is sign a piece of paper saying, I have a medical objection, I need a medical exemption, I need a religious exemption, or I need a conscientious objection, and that's it?
I would agree with your analysis of the bill. That would render those types of conversations irrelevant. The employer is required to grant the exemption upon the request.
Not only irrelevant, but not allowed.
Well, I mean, I suppose I would answer yes, but from an employer perspective, if there's no point in having the conversation because of what the law is, they're not going to have the conversation. I do remember what the other issue was, Mr. Chair, and you had asked about companies, how many people wouldn't want, how many unvaccinated employees are there in companies, if you can sort of suss out how many got the vaccination because they were forced to. I only have anecdotal information on that, but it's pretty good anecdotal information. At the point last fall where the presidential executive order required private sector employers of 100 and more to require vaccinations, we heard from a number of our manufacturing members that they were very concerned about this mandate because they estimated they would lose 20 to 25% of their employees. Now that was before the mandate was implemented, so there was no, and they didn't have mandates in their workplace, so there's no reason to believe anyone had been forced to take a vaccination. But their estimate and this is, by the way, consistent with manufacturers who talked to me around the state, they estimated 20 to 25% of their employees would be lost.
And that would go almost exactly in line with my personal situation with our pilots. It was about the same percentage.
Now, I guess I should balance that, and I know this wasn't what you were asking. We had other employers of 100 or more who actually implemented the vaccine mandate before it went into effect. And so there were some employees who faced that vaccination perhaps unwillingly. And those employers reported that there was some resistance and some grumbling, but more often than not, people chose to get the vaccine rather than lose their job.
Key point. Let me ask you something on, let's go back to the religious exemption versus the conscientious exemption. If there's an individual who can't truthfully claim a religious exemption, but can that person still be ethical and moral without being religious?
Certainly, I probably fall into that category myself.
As would I. So that's one of the points I was trying to get asked before is what is the net effect difference of a person who claims a religious exemption versus a conscientious objection?
Yeah,
I
well-
understand how the bill is written, I get all that, but I've yet to hear anybody who's opposed to this say, yeah, the net effect on the individual is the same.
I guess I would suggest that if you're going to go down that road, you could simplify this bill by just saying private sector employers or educational institutions that accept federal and state money are prohibited from implementing vaccine mandates, and just leave it at that. Because the reality is, there is a difference between what is commonly accepted as a religious exemption, where an employer has the right to query about that, and a conscientious objection where there's no query that can take place.
Okay, we're getting a little philosophical here,
We are.
but again, I'm going to go back to my personal case because that's what I know. When they came out with the federal contractor mandates, and I was given the choice of get a medical or get a religious exemption, and our company was pushing it. Just do it, do it, do it. Right? I'm healthy. I couldn't claim a medical. I couldn't claim truthfully a religious. Well, just go put one. No, I'm not going to do that. I need that other category personally because I don't fall into that religious or medical. So I think that's the importance of having this category. Does it make sense?
It makes sense, but it also renders any type of vaccine mandate irrelevant, because there is no mandate if a person just says, I don't want to get it. That there's no mandate that takes place.
Exactly. Thank you. Anybody else?
Mr. Chair.
Yes.
So just one thing, into this objector you're talking about conscientious objector versus religious, and probably an interesting statistic is New Hampshire is considered the top non-religious state in the entire country. A lot of people consider themselves spiritual, but don't consider themselves religious. And to a point where you run into some problems with the religious exemption and claiming one, I'm going to use Catholicism as a great example, is that the Catholic Church has come out and said, if you want to get the vaccines, it's okay, but also we recognize that there could be some moral religious exemptions relative to the stem cell research that's behind it. So we also agree that if you don't want to get it, that's okay too. So where does that person fall? Is it really a religious exemption when the church says yes you can, but also says no you can't? How do you claim I'm not going to get it? Because the church hasn't taken a position. So I don't know how, this is where conscientious objector falls in, or the right of conscience falls in, and says, well, my church doesn't explicitly prohibit me from getting the vaccine. I have a moral belief that I should not get it because it's based on stem cell research. And this is why the right of conscience is so important.
Yeah, I would respectfully disagree. At the point, I was with you up until the point where you said, my church or my religion has said I can get the vaccine if I want to. However, I also, as a part of my religion, have strong feelings about stem cell research, and my church has made me aware of that also. I would think that would be, for most employers, a legitimate religious exemption.
Representative Prout.
Two questions for Representative Lang, if you have a moment. Do you know when the right of conscience was added to the New Hampshire Constitution?
Give me 30 seconds. I will say the first time it was used, conscientious objector, most people equate it with law, with war, and the conscientious objector right to bear arms. It was actually, that's not true. The first time it was used was relative to vaccines in England in 1895. And it was, in England, they had a mandatory vaccine requirement. Prior to that, in 1888, I think they put it in. There was so much objection that they put another law in that granted the right of conscience to people to not get vaccines. And that was in 1895.
That
To
was
answer your
England.
question about the right of conscience, June 2nd, 1784.
1784. So that sounds like it was part of the original draft.
Yeah, June 2nd, 1784.
That sounds like it was part of the original draft.
It was.
do you think that what we're talking about, the difference between a conscientious objection and religious exemption, is just a difference in, you know, the modern way we've evolved in viewing it as opposed to how they viewed it back then? And back then, as they were trying to talk about it, conscience objection and religious exemption weren't as clearly delineated and were really the same thing they were trying to talk about? Do you think there's a lot of overlap there or not?
Again, I'm not a historical expert, but I do know that, again, based on a lot of my readings, that, again, a lot of the founders were deist types that believed in some sort of spiritual being, but didn't necessarily believe in a lot of religious, specific churches, so to speak. So I think they were recognizing the fact that there's morality and there's religiousness, and that those two things can be the same, can also be separate.
Thank you.
Mr. Chair, if I could make one more comment, since this subject about conscientious objections have come up. In line 6, where it says the state of New Hampshire has affirmed in statute the natural, essential, and inherent right to individual bodily integrity, I am sure that's true. But the state of New Hampshire has also affirmed in statute the right of employers to implement health and safety regulations in their workplace. For example, you can't, for most places of employment, if you show up work high as a kite from smoking marijuana, you won't be allowed to do your job, and you may be subject to discipline. The same holds true for drinking. Again, those, by this, I think would be natural, essential, or inherent rights of individual, or right to individual body integrity, and yet we do have in statute the ability for employers to impact that behavior.
I would not disagree. I will make the point that legislative findings do not end up in our statutes. Anybody else for Mr. Juvet? Thank you.
Thank you, Mr. Chair.
My name is Kate Fry. I'm from New Futures. I'm not in front of this committee very often, but we are a public health organization that works on public health policies and the health and wellness of New Hampshire residents. And I'll be very brief. I just did want to underscore a little what Pam DiNapoli said so well, is I think one of the issues here is really understanding the public health importance of vaccines, and I'm particularly concerned with the part of the bill that focuses on colleges and universities and just offering a conscientious exemption on all vaccines. Most colleges require childhood vaccine and meningitis vaccines, hepatitis B. And this is really understanding the college nature. And I just sent my last child to college, and you know how close kids are on campus and sharing a room. And I can testify to that. My husband and I had to take turns in and out of their tiny room. We really have to understand that environment to understand the importance of these vaccines. And it's well noted that anytime you offer a conscientious or philosophical, it's usually called personal exemption, anytime you offer that, the rates of vaccinations just go down, and you do start to see the outbreak of diseases. And for those of you that don't know, but meningitis is a very real concern on college campuses, and the outbreaks are almost always deadly. So I just think we really need to be aware of this. And when we talk about conscientious, we have to understand that there are people who can't get vaccines for medical reasons, and no one has the right to infect other people. And it really, we have to keep that in mind, that these diseases are deadly, and they can be, in most cases, they've been completely eradicated. But once we bring down that firewall, we will start to see increased outbreaks.
Thank you. Any questions? I just have one. You mentioned meningitis. Is that, and I don't know the answer, is that a required vaccine for college?
It is
students?
required at most universities, and I did just check before I came up. It is required at UNH. Now it's almost always required since that vaccine has been approved. And I will say most universities and colleges have also mandated the COVID vaccine. And I know both my daughters were thrilled to be able to get that vaccine and hope for life back to normal at college.
I'll follow up. The meningitis vaccine, once that is taken, does that prevent that individual from getting that?
It's a very foolproof vaccine. I mean, no vaccine is 100%, but it's made a huge difference in outbreaks in colleges and universities. And I can get you more information on that.
And as far as COVID, is that a foolproof vaccine like meningitis vaccine?
I think we're still learning about COVID and it's a little bit different because we've had so many variants. But again, going back to this bill, it's not just COVID, it's all vaccines. So we should be concerned about that.
Thank you. Anybody else? Thank you.
Mr. Chair?
Yeah.
If I may,
Yes.
just an interesting fact point that I think is important to this discussion, especially now that we're on the topic of schools, was, when it comes to vaccinations, one of the big questions around herd immunity, right? For public health purposes, herd immunity is important to make sure we reach herd immunity. Herd immunity is established at a baseline of 70%. That was the number that is generally said that's the baseline of where herd immunity begins, and it gets better as your percentage increase. Would anybody care to hazard a guess what the percentage of inoculations are and vaccinations are in our public school system? Even given we allow for exemptions. 94%, right? 94% of the students have agreed to get vaccinated. The parents have agreed to get vaccinated. So we're well beyond the herd immunity. So sometimes when we talk about this public health concern, we recognize that we heard from Mr. Duvet, 80 to 95% of their employees chose to get the vaccine. So we're not talking about a herd immunity problem here, right? We're not talking about the fact that we're going to have mass outbreaks. Nobody's ever going to get it. The reality is that New Hampshire, well before COVID and well before these, were one of the top nations for people just choosing to get vaccine. What we're recognizing here is the individual that has an objection for one reason. That's a small minority of our population, but it's still a population and it deserves protection. So that's what we're talking about.
Thank you. Is there anybody else in the gallery who wished to speak? Seeing none, any other questions, comments? Representative Sullivan.
Some comments. I don't care for this bill. I don't intend to support this bill. There are limits on rights. For example, we all know you can't yell fire in the movie house. That's a limit on the First Amendment rights. I would suggest that crying fire or refusing to get a mandated vaccination in a medical facility ought to be an exception. I would say the same for a college environment. Same for a county nursing home. And same as well for state or federal prisons or county. So I would suggest that, although I don't support this bill in any form, it could be improved by carving out some exceptions for those categories that we've received a lot of testimony about, especially the medical. If we were only going to choose one, the medical one is a critical one because of the the Medicare and Medicaid aspect. I think this bill could be vastly improved by making sure that these conditions do not apply to medical-related employment. If the committee is interested, I would be willing to try to put together a new amendment to that effect. Again, I probably still wouldn't support it, but it would be better than what we have now. Thank you.
Anybody else? Representative Avalani.
Thank you, Mr. Chairman. I would just want clarification on the public funding that was suggested.
You're talking about in line 13, one time versus ongoing and that kind of thing. Yeah. Okay. Anybody else? Okay, seeing no more comments or questions, I guess what we Representative Avalani.
Just a question for Representative Lang, if it's appropriate.
Absolutely.
Representative Lang, could the, under the medical exemption, could that include the right of conscious exemption, so we don't have a third leg, so we could actually expand the definition of a medical exemption?
I'm sorry, can you restate the question? I couldn't hear you.
Under medical, given that doctors have the right of conscience exemption, could we expand the definition of a medical exemption under this protection?
Medical exemptions are governed by the ADA as a general rule of thumb. So I'm not sure that we could expand medical exemptions to include the right of conscience, if that's what you're asking.
That is correct. Has that been fleshed out at all? If it could be expanded?
Under the medical exemption to include right of conscience?
Correct.
Yeah, again, right, the medical exemption, and maybe someone, Mr. Duvay may have a better answer to that, but my understanding is the medical exemptions are driven by the ADA law, the religious exemptions are driven by the Civil Rights Act law, and conscientious objections are driven by our Constitution.
Thank you, Mr. Chairman. Thank you, Representative Lang.
Anybody else? Okay, so coming out of the subcommittee, I guess we will take a vote on recommendation, whether or not this amendment proceed, or we recommend it when we get back to full committee. I know we've talked about, Representative Avalani has talked about the wording in line 13. I'm thinking we can clarify that before we bring an amendment to the full committee if we do that. So, with that, I'll ask the secretary to take a vote, I guess, or call a roll call vote on a recommendation to proceed.
Yes, so this will be for a recommendation to proceed.
Before you do that, I want to make one comment. We need to recognize that there is a severability clause in this bill. And I think it's fair to say that the ultimate determination on a lot of this stuff regarding COVID is still in the courts. The Supreme Court has heard arguments. They've placed a lot of their decisions back on the federal courts. So a lot of this stuff is still yet to be settled, and it'll probably be a while before it is. And the reason we're going through a lot of this is because I think of the uniqueness of COVID itself and all the things that have happened. So I'll call the roll.
Mr. Chair, if I could.
Representative Sullivan.
I would just want to point out, I hear what you're saying about the severability. I think it's good that it's in there. However, with the CMS questions and concerns, no one says we have to take funding from the Medicaid and Medicare. So essentially, it's not illegal to have this bill. It would simply cause us to forfeit all of that funding. So I don't think
potentially.
Potentially.
Yeah.
But the risk is there, and I don't think the courts are going to say, the courts might say, yes, you're going to lose the funding, but I don't think it would say the bill is unconstitutional or in violation of federal law.
Representative Lane.
Thank you, Mr. Chair. I just want to be clear on what you're voting on, so I know what I have to do. So it sounds like if the vote would be to recommend OTPA, but the amendment may be slightly adjusted to deal with the language relative to regularly versus one-time language.
I don't think we can vote the amendment ought to pass. I think we can vote to recommend it to the full Labor Committee. Is that correct? Yes.
Thank you.
I believe the form has a motion on it, does it not? It's been a while since I looked at it.
I have never done one of these, so I've...
You can be as formal or informal as you want. You can make a recommendation from the subcommittee. Each of the members of the subcommittee are going to have their right to discuss their opinions of what went on in the subcommittee when they testify. So this is not as formal as our other votes. The goal here is to get more detail, flush out possible amendments and possible problems to bring a better answer to the other representatives that were not here.
Better answer and possibly a better product.
It would just be helpful if we know exactly what we're voting on.
Okay, so I will make the motion that we support the amendment when we meet as a full committee with a labor committee with some possible changes, clarifications to the amendment. Yes?
Just a question as to why the severability is in section 200.
I'm sorry, can you say that again? Maybe I can answer it.
The severability is under section 200, not 275.
So again, I think the severability is in two different locations. If I'm not mistaken. Hold on, let me just confirm that. Yeah, so it's on line 24 on page 1, if any provision of this section which deals with the labor laws. And then if you scroll down under the post-secondary education is also a severability clause. So there's two different severability clauses in there.
Should there,
Yes.
the follow-up?
Yeah, oh yeah.
Should there be one under the medical side or DHHS side for severability if something like this happens?
The severability would have to stick with the chapter of law that you're referencing it to. So in this case, we're referencing 275-78, and that's the chapter of law, and we're talking about severability of that chapter of law or that specific RSA. So if any provision of that RSA is deemed unconstitutional, only that provision is struck from the law, not the entire law.
Thank you.
So the motion's been made. Is there a second on that? Representative Avalani? And call the roll.
I will call the roll. Representative Avalani.
Yes.
Myself, yes. Representative Sullivan.
No.
Representative Bouchard.
No.
Representative Turcotte.
Yes.
It is 3-2. The motion passes.
Okay. So with that, I will close the subcommittee hearing on HB 1210.
Mr. Chair, I'll reach out to the Labor Department, see if I can get help from them on drafting what that language would look like relative to federal and state monies. And
Deputy
I'll
Commissioner
present
Ogden.
that-
Yes,
And I'll
very
present
good.
that back to you.
Okay, thank you. Thank you.
Infantine. Here. Seaworth. Here. Avaloni. Present. Callum. Present. Mackey, myself, present. Love. Love. Warden. Here. Turcott. Here. Prout. Here. Boyd. Here. Huff. Here. Sullivan. Here. Susie. Here. Schultz subbing for Baruti. No Schultz.
Not here yet.
Okay. Cahill. Here. Fellows subbing for Di Silvestro.
Here.
Schmidt.
Here.
Toomey. Here. Bouchard. Here. Adjutant.
Here.
Manival.
Here.
Mr. Chair, I'm sorry that I missed your roll call, but I'm Representative Chris Schultz. I forget who I am filling in for.
You're filling in for Baruti. Yep.
Well, that means you have to buy the beer, so. Please allow me a moment. We're going to find out where our missing representative is. Representative Love is on his way. We have a lot of bills to go through today. I would appreciate if individuals would try to get their, if they are making a motion or if they are writing the blurb, either for or against, that they try to get this to by Monday. Preferably Saturday, so I don't have to read these on vacation. But you guys do a great job usually getting them through, I think. So if you wouldn't mind, I'd appreciate getting them to me as soon as you can. Also, try to keep decorum today, guys. There's going to be bills that people want passed that aren't going to get passed and vice versa. And, you know, we got a lot going on here. So I'd like to, I'm going to, if people don't mind, I'm going to skip some order here. The first bill I'd like to bring up was House Bill 1076, and Representative Adjutant.
Thank you, Mr. Chairman. I move ought to pass on HB 1076 and would like to offer amendment 2022-0630H.
Is that motion seconded? By Representative Manival. You're recognized to speak on your motion.
Thank you, Mr. Chairman. this bill, this amendment to HB 1076 does a lot of good. It removes a lot of the information gathering requirements that were placed on the Department of Labor, dramatically simplifies the bill, and keeps the main enforcement mechanisms in place. And if I haven't said it before, I just want to publicly say thank you for the work that you and I both did on this. I think this makes a good bill better, and I would ask the committee vote in favor of OTPA.
Thank you. Any individuals wishing to speak on the amendment? Seeing none, Mr.
Chairman,
Yes.
could I have the amendment number repeated?
2022-0630H.
Thank you.
I'll start with call the roll, please.
Seaworth,
Yes.
Avalani. Callum,
No.
Mackey, yes. Love, not here. Warden. Turcott.
No.
Prout,
Yes.
Boyd. Huff,
No.
Sullivan,
Yes.
Susie. Schultz,
Yes.
Cahill,
Yes.
Fellows,
Yes.
Schmidt,
Yes.
Toomey,
Yes.
Bouchard,
Yes.
Adjutant,
Yes.
Maniville,
Yes.
Infantine.
Yes.
Fifteen to 5 passes.
Motion for the amendment is passed. It's open to further motion.
Mr. Chairman,
Yes.
move OTPA on HB 1076.
Seconded by Mandeville. You recognize to speak your motion?
Thank you, Mr. Chairman. I think that this is a very good piece of legislation now that ensures that rights that are already enshrined into law for bathroom breaks and meal breaks and rest periods cannot be denied due to productivity quotas. And I think this provides a lot of transparency to new potential employees as to what productivity quotas they would be subject to. With that being said, I move OTPA on this, and I would encourage the committee to vote yes.
Anyone else like to speak on the motion? Wow, okay. Seeing none, please call the roll.
Seaworth,
No.
Avalani. Callum,
No.
Mackey, myself, no. Love, not here still. Warden,
No.
Turcott,
No.
Prout,
No.
Boyd. Huff,
No.
Sullivan,
Yes.
Susie. Schultz,
Yes.
Cahill,
Yes.
Fellows,
Yes.
Schmidt. Toomey. Bouchard,
Yes.
Adjutant,
Yes.
Maniville,
Yes.
Infantine.
Yes.
11 to 9.
Motion passes. Yes. I don't know. I'm waiting for someone to say if they'll be preparing the minority report.
Sure.
Well, there will be a minority report, correct? Next bill, House Bill 1088, relative to employment protection for COVID-19 in the workplace. Representative Huff, you're recognized for a motion.
Thank you, Mr. Chairman. I move that we render HB 1088 an act relative to employee protection from COVID-19 in the workplace inexpedient to legislate. I ask that my motion is seconded, and I ask to be able to speak to my motion.
Okay, seconded by Representative Warden. You're recognized to speak on your motion.
Thank you, Mr. Chairman. While I applaud the author's attempt to grant people the freedom to be vaccinated and or use PPE in their workplace, such freedom already exists, and it is not the government's purpose to grant or deny individuals medical choices. So this bill would seek to disallow discrimination of which we see no evidence of here in New Hampshire. Furthermore, it does not address discrimination in accordance with like protected classes. Finally, New Hampshire's an at-will state as far as working, and this bill is just not necessary. Folks can get a vaccination, and they see as they desire. So I ask that you ITL this. Thank you.
Thank you. Representative Sullivan.
Thank you, Mr. Chairman. I'm going to oppose the ITL motion on the basis that there very well could be some employers out there who would ask their employees not to wear PPE. And I think someone should have a right to put on a mask if they're trying to protect their health. So I would oppose the ITL.
Representative Sullivan, Representative Seaworth.
Thank you, Mr. Chairman. I am going to speak in support of the ITL motion. The sponsor stated while he was advocating for his bill that it was possibly unnecessary or at least probably harmless. And I'm concerned it's just a couple of sentences. It's very broad. It applies to everybody. You know, what are we missing in not giving this a lot of thought? I certainly agree with the previous speaker that an employer probably is wrong to take an employee who wants to wear some sort of protective face mask or whatever and say, you know, I don't like that, you can't wear it. But what if it's a safety issue? What if the kind of paper fibrous masks are a risk because of the temperature of the machines that you're operating in? Have we, in this language, made the kind of exceptions that we usually do when we consider a bill of this sort? So I would support the ITL if for no other reason than I don't think this language is yet fully formed, and if we were to go down this road, I think we'd need to spend some more time doing it right. Thank you.
Thank you. Anyone else like to speak? The chairman will. The bill as written has inconsistencies. I don't see it passing any muster of law or having anything needed. The presentation was inconsistent after questions were asked. And while we have a number of other of these bills coming up, I'm sorry, this language is written is not ready for prime time. It is not ready to be a law, and it was poorly crafted as a bill. Seeing no other comments, motion on the floor is inexpedient to legislate. Mr. Clerk, please call the roll.
Seaworth,
Yes.
Avaloni. Callum,
Yes.
Mackey, yes. Love? Not here. Warden,
Yes.
Turcott,
Yes.
Prout,
Yes.
Boyd. Huff,
Yes.
Sullivan,
No.
Susie. Schultz. Cahill,
Yes.
Fellows. Schmidt,
No.
Toomey. Bouchard,
No.
Adjutant. Mandible,
No.
Infantine,
Yes.
I must have counted wrong, sorry, excuse me. 11 to 9, ITL, yes.
No.
No, I must,
Wanna try that again?
I have a counting issue here. 1, 2, 3, 4, 5.
Should be a tie. Is he?
Oh, we have one? Yeah. It was 21 people. Yeah, so it's 11, yeah, it's 11-9, 20 people.
All right, my
Yeah.
apologies.
Yeah,
I
Cahill
did not
voted.
hear Representative Cahill's vote.
Yeah. Sorry about
Um,
that.
The motion passes. Will it be a minority report? You can let me know. Next, bill, House Bill 1363, relative to the enforceability of non-compete agreements in the areas of which there is determined to be a critical shortage of workers. Representative Seaworth is.
Thank you, Mr. Chairman. I would like to make a motion of ITL.
Second?
Seconded by Turcott. You're recognized to speak in your motion.
Thank you. We had two bills trying to address a very similar issue relative to non-compete agreements, vaccine mandates in the workplace, and what happens to the employee who leaves an employer because of it. With the agreement of the sponsor of this bill, I'd like to focus our efforts on HB 1089, and therefore I'm asking that we ITL this bill as redundant.
Oh, it was seconded by Turcott. Sorry, gotta get the clerk to
Can't get with it here.
try to find his right paperwork here. My apologies. Sorry, John. Motion on the floor is inexpedient to legislate. It was seconded. You spoke to your motion. Is there anyone else who would like to speak for or against the motion? I would like to mention I did speak with Representative Roy and let him look at the two different bills, and he offered that we should ITL this bill. Seeing no other individuals wishing to speak, Mr. Clerk, would you please call the roll?
Seaworth,
Yes.
Avaloni. Yes. Callum,
Yes.
Mackey, yes. Love not here. Warden. Yes. Turcott,
Yes.
Prout,
Yes.
Boyd. Yes. Huff,
Yes.
Sullivan,
Yes.
Susie,
Yes.
Schultz,
Yes.
Cahill,
Yes.
Fellows,
Yes.
Schmidt,
Yes.
Toomey. Yes. Bouchard,
Yes.
Adjutant. Yes. Mandible,
Yes.
Infantine,
Yes.
unanimous then.
Without objection, consent agenda? Thank you.
I'm okay.
Sorry, just let
I
me.
just can't count.
That's all right.
Next.
1410.
1410.
Next bill will be House Bill 1410. Relative to cause of action involving private business entity. Representative Huff is recognized for a motion.
Thank you, Mr. Chairman. I I move that this bill be ITL, and I ask for a second and to speak to my motion.
Representative Warden, second the motion. You're recognized to speak.
Thank you, Mr. Chairman. This bill was one of the bills that, the COVID bills that we'd put together for the subcommittee. So it's been taken apart and reformulated, so this one is no longer necessary. So I ask that you ITL this, and that's it. Thank you.
Thank you. I'd like to also make the last comment. This was very convoluted, if you all recall. If you are on your way to the drugstore to get a vaccine because your local bakery wanted you to have a vaccine before they would let you into their bakery, and you got into a car accident on the way to get your vaccine, you could have a cause of action against the bakery because you had to go get a vaccine, as well as against the bakery if you somehow became ill because of the vaccine. And I think that was just something that was a little too broad. We have a motion on the floor of ITL. It's been seconded. There's no further comments. Mr. Clerk, please call the roll on 1410.
Seaworth.
Yes.
Avaloni. Yes. Callum.
Yes.
Mackey, yes. Love, not here. Warden.
Yes.
Turcott.
Yes.
Prout.
Yes.
Boyd. Yes. Huff.
Yes.
Sullivan.
Yes.
Susie. Yes. Schultz.
Yes.
Cahill. Yes. Fellows.
Yes.
Schmidt.
Yes.
Toomey. Yes. Bouchard. Yes. Adjutant.
Yes.
Menaville.
Yes.
Infantine.
Yes.
20-0.
Motion passes on House Bill 1410. Without exception, or excuse me, yeah, without exception of the consent agenda. Thank you. House Bill 1415. To employee health screening reimbursement.
Mr. Chairman, I'd like to move IPL.
Just going to give the clerk a moment here.
We can find it. Out of order here. That was Seaworth. Seaworth and Turcott.
Representative Seaworth, you would like to you're recognized to speak to your motion?
Thank you, Mr. Chairman. This was a bill that, with the help of the Department of Labor, it was explained to us how the provisions of that this bill would seek to put in are actually already in law. If you go up to the top of this section, section number 3 talks about how medical tests, which would include this health screening, is to be covered by the employer. And in my opinion, and in the opinion of the department, this law would not be needed. So I ask for an ITL.
Avalani, did I see your hand raised? Did you like to speak? No. Okay. Representative Sullivan?
I agree with Representative Seaworth.
Thank you. Thank you for that. Do I see anyone else wishing to speak on this bill? Seeing none, the motion is inexpedient to legislate. It's been seconded. Representative, Mr. Clerk, would you please call the roll?
Seaworth,
Yes.
Avalani. Yes. Callum,
Yes.
Mackey, yes. Love not here yet. Warden,
Yes.
Turcott,
Yes.
Prout,
Yes.
Boyd. Yes. Huff,
Yes.
Sullivan,
Yes.
Susie. Yes. Schultz,
Yes.
Cahill. Yes. Fellows,
Yes.
Schmidt,
Yes.
Toomey. Yes. Bouchard. Yes. Adjutant,
These two.
Maniville,
Yes.
Infantine,
Yes.
20-0.
Without objection to the consent agenda? Just so folks know the schedule, it is my intent, I know we've only been here a short period of time, but unless everybody says no, I wanted to take a break at 12:30 so people could at least get something for 30 minutes to eat and come back, unless everyone raises their hand and says, no, we don't want to eat at 12:30. I just don't want anyone, if we go till 3 or 4, being, so that is my intent. Next bill I'd like to call is HB 1508 FN, prohibiting discharge of firefighters. I'd like to call on Representative Avalani.
Thank you, Mr. Chairman. I move ITL.
Second?
Motion on the floor is expedient to legislate, and it is seconded by Representative Turcott. Representative Avalani, you're recognized to speak to your motion.
Thank you, Mr. Chairman. It raised a lot of questions from this committee as to how this would be beneficial, given the fact that there was nothing that the Labor Department could bring to us that it was a problem. So I would just move ITL.
Would anyone else like to speak on this bill? Representative Sullivan.
Thank you, Mr. Chairman. I'm going to oppose the ITL. I think we all received amendment number 0681H, and I would move that amendment if the ITL motion is defeated.
Representative Maniville.
Thank you, Mr. Chairman. I understood that the amendment to which Representative Sullivan referred clarified the bill so as to make it applicable only to appearing for work rather than leaving work. As I disclosed at the hearing, I'm an officer in a small town volunteer fire department, and I value what this bill would permit. And so I would support the amendment and an OTP. Thank you.
Representative Seaworth.
Thank you. I'd like to speak in favor of the ITL. As Representative Avalani stated, during the testimony, the sponsor said that he wasn't aware of an employee who had an issue with this in the course of employment. He just thought the lack of this protection might deter people who would consider volunteering from volunteering. So I agree that it's a possible problem, but I'm not sure we're fixing a problem that's actually out there. And again, it's kind of general language meant to apply to everyone, and we're not considering the exceptions that would need to be in such a law. For example, if I look to my right here, what would happen if one day my friend called in 10 minutes before his flight was supposed to take off and said, you know what, could you hold my flight? I'm going to be an hour late because I was on a fire call. I'm just not going to be able to get in on time. Some jobs that works, and I think there's a lot of employers out there that really support the need for volunteers in these services, but there are other jobs that it just can't work. It's incompatible with the business model. And I think that we as legislators need to leave it up to the employers to figure that out and make the decisions of how they will support their employees who also volunteer appropriately. Thank you.
Representative Cahill.
Thank you, Mr. Chair. I understand the example that my friend from Pembroke has given, and I don't know that, I think we can rely on the judgment of people who volunteer for these roles, that they would know that the job that they have or may take is inconsistent, and I would expect that a person would take that into account when applying for a job and understand that being a volunteer fireman is an important role in the community. If they need to have a different job that can't accommodate the schedule, such as an airline pilot or many others, I suppose it would be to their judgment. So I'm in favor of the amendment if we get an opportunity to consider it.
Representative Turcotte.
Thank you, Mr. Chairman. As Representative Seaworth mentioned, I think this bill is trying to fix a non-existent problem. The question I did ask Representative Deshaies was how many times was he aware of this actually being a factor, and the answer was 0. Also, as Representative Seaworth points out, that you can't apply a broad bill like this for every individual business or employee out there. I believe we have a system that works fine. I don't believe we need to be putting our thumbs on employers. I can just see the amount of legal potential for lawsuits and legal issues that this would bring in, and I just am definitely in favor of the ITAL motion. Thank you.
Representative Manable.
Yes, thank you, Mr. Chairman. I apologize for not addressing this in my first time around. I appreciate also Representative Seaworth's and Turcotte's and Cahill's thoughtful comments on this. I should have mentioned that while I also remember the testimony relating to the issues of finding volunteers to sign up, I can also say that reading this bill and the amendment, that it relates to the question of their turning up for an emergency, not just to whether or not they decide to join the force. A lot of employees who serve on volunteer departments could, if they're called some period of time prior to their shift, and if it is reasonable under the circumstances, could decide they can't afford to go to the call because of the fact that they would have to report subsequently to work. So it's for that reason also that I support the amendment and an OTP. Thank you.
In 1970, my family moved into the little sleepy town of Amherst, New Hampshire, where there were more hunters and cows than there were people. We had a volunteer fire department, and later on we got our own ambulance and our own volunteer rescue squad, and it was the pride of the town, the individuals that would become EMTs and be ready. There was one gentleman who was the chief, who was deliver your laundry to you, or your dry cleaning directly delivered to your home. Employers wanted volunteers to be firefighters and EMTs. They wanted it because if it ever happened to them, if they had a heart attack, they wanted to make sure someone was coming. If there was a fire, they wanted to make sure someone was coming. And there was never a time that I can recall any problem with employers not wanting to give people time off to be able to offer that service. I don't disagree with the concept of the bill. But our job here, in my opinion, is not to necessarily just agree to a concept, but look at what the need is. We have had many bills come in front of us regarding first responders, and they fill the room talking about why it's a good idea. And then we get letters, and we get phone calls, and we get emails as to why they want that bill passed. It should be noted that one individual came and supported this bill, and it was a sponsor. Not one volunteer fire chief has contacted me or written me an email or written to the entire committee. So how important is it? How much of an issue is it? If I do not believe we should be passing legislation where no one has come to us other than one individual saying that they should have this. I just don't think we should do it. I say, I'm all in favor of the volunteer fire department. Again, I just told you this lengthy story about my little upbringing in Amherst. Okay? It was important. I'm glad we had it. I have fond memories of it. So, if we don't have a problem, and there's not, I also haven't heard that we don't have enough volunteer firefighters or volunteer EMTs in these towns because of their jobs. So, I'm sorry, I can't see supporting something that we don't have a problem that we're trying to solve. Is there anyone else willing, like to speak on this motion, or on this bill? Representative Schultz.
Thank you, Mr. Chair. Just a question for anyone who can answer it. I assume the idea also comes from how National Guard folks are treated. I know that, I believe there's a law protecting them and their jobs, or at least there have been bills to say that. Was that part of the, since I missed the hearing, is that part of the reasoning behind this, if there weren't any specific incidences, is that what the impetus behind the bill is?
I will answer there was nothing related to anything to do with the National Guard or such. The belief was that sponsor put the bill forth, that he had a feeling and a discussion with at least a potential individual who was considering being a volunteer firefighter, and felt that unless there was a bill that would protect them for being late or not missing, that they needed this to be able to feel comfortable with volunteering. If anyone disagrees with what I have answered that question, you're welcome to chime in. Representative Love, we are already in this bill, so you will not be able to vote on this. All right. Anyone else like to speak on this bill? Seeing none, the motion on the floor is ITL. Mr. Clerk, would you please call the roll?
Seaworth.
Yes.
Avalani. Yes. Callum.
Yes.
Mackey, yes. Warden.
Yes.
Turcott.
Yes.
Prout.
Yes.
Boyd. Huff.
Yes.
Sullivan.
No.
Susie. Schultz.
No.
Cahill. No. Fellows.
No.
Schmidt.
Yes.
Toomey. Yes. Bouchard. No. Edgston. No. Manival,
No.
Infantine,
Yes.
12-8.
Minority, please let me know if there's going to be a minority report. Representative Seaworth?
Mr. Chairman, if I could ask the minority to repeat the amendment number that they're going to support. So, amendment 06818. Thank you.
I'm going to try to get through a couple more bills. I know there's not much discussion. House Bill 1351, prohibiting certain employers recognize Representative Seaworth as, just give it a second, Brian.
I got it.
1351.
Yep.
Representative Seaworth, you're recognized for a motion.
I move ITL.
Second by Representative Avalani, you're recognized to speak to your motion.
I'm going to repeat the sentiment from my fellow representative. This is another COVID-related bill that has a lot in common with a number of bills we got in this session, and I think we're deferring all the discussion as well as the changes to House Bill 1210. For that reason, I ask that we ITL this one as redundant.
Would anyone else like to speak on House Bill 1351? The motion on the floor is an expedient to legislate. Seeing no more comments, Mr. Clerk, would you please call the roll?
Seaworth,
Yes.
Avalani? Yes. Callum?
Yes.
Mackey, yes. Love?
Yes.
Borden?
Yes.
Turcott?
Yes.
Prout?
Yes.
Boyd? Yes. Huff?
Yes.
Sullivan?
Yes.
Susie? Yes. Schultz?
Yes.
Cahill?
Yes.
Fellows?
Yes.
Schmidt?
Yes.
Toomey? Yes. Bouchard? Yes. Adjutant?
Yes.
Manival?
Yes.
Infantine?
Yes.
21-0.
Without exception, on the consent agenda. House Bill 1358. Representative, I originally had Representative Prout, you were recognized for a motion.
Thank you. I'd like to move ITL.
Motion on the floor is inexpedient to legislate by Prout, seconded by Representative Turcott. Representative Prout, you're recognized for your motion, to speak to your motion.
I'm sorry, Mr. Chair, which was the bill number again? I apologize.
That's right, no worries, 1351.
58, I believe.
Sorry, 1358. I'll give everyone a chance to find it. And Representative Prout.
Thank you, Mr. Chairman. I think the sponsor had an interesting idea here, and he tried to write an amendment to kind of tone it down and do something that we could support. The amendment didn't come out of OLS as I had discussed with him, and so I think it's on him to continue to let the idea percolate and bring it back next year if it's something that he can crystallize and get us in a form we'd want to move forward with. But for right now, I would recommend we vote this bill ITL.
Representative Turcott.
Thank you, Mr. Chairman. Following up on Representative Prout's comments, this was yet another one of the bills that we rolled into a subcommittee. There were actually pieces of this that we did include in some form into another bill we will be talking about at a later date, so I'm in agreement on the ITL motion.
Thank you. I would also like to add that there are other, blood tests and such taken urine tests taken after accidents. Some employers require, some insurance companies require. This would interfere with that if it were to pass. Seeing no additional comments, the motion on the floor is an expedient to legislate. Mr. Clerk, would you please call the roll?
Seaworth.
Yes.
Avaloni. Yes. Callum.
Yes.
Mackey, yes. Love.
Yes.
Warden.
Yes.
Turcott.
Yes.
Prout.
Yes.
Boyd. Yes. Huff.
Yes.
Sullivan.
Yes.
Susie. Yes. Schultz.
Yes.
Cahill. Yes. Fellows.
Yes.
Schmidt.
Yes.
Toomey. Yes. Bouchard. Yes. Adjutant. Yes. Mandible.
Yes.
Infantine.
Yes.
21-0.
Without exception and consent agenda, please. Thank you. I'd like to bring up House Bill 1377. Additional 6 months of unemployment benefits if you're fired for not taking a vaccination.
Mr. Chairman.
Representative Avaloni, you're recognized for a motion.
Thank you, Mr. Chairman. I move ITL.
Motion on the floor is inexpedient to legislate. Second. Seconded by Representative Boyd.
Okay.
Oh, no, I know. Just waiting him to catch up. Sorry.
I'm good.
You are recognized for your motion.
Thank you, Mr. Chairman. We heard significant testimony from Employment Securities about adding 6 months. It would be a burden on small businesses that, and all businesses that fund that unemployment benefits. So for that reason, I would move ITO.
Would anyone else like to speak on the motion? Seeing none, the motion on the floor is inexpedient to legislate. It's been seconded. Mr. Clerk, would you please call the roll?
Seaworth.
Yes.
Avaloni. Yes. Callum.
Yes.
Mackey, yes. Love.
Yes.
Warden.
Yes.
Turcott.
Yes.
Prout.
Yes.
Boyd. Yes. Huff.
Yes.
Sullivan.
Yes.
Susie. Yes. Schultz.
Yes.
Cahill. Yes. Fellows.
Yes.
Schmidt.
Yes.
Toomey. No. Bouchard. Yes. Adjutant. Yes. Mandible.
Yes.
Infantine.
Yes.
20-1.
Without objection, the consent agenda, please. I don't know if I'm saying that right. Thank you. The next bill I would like to address is House Bill 1143. Keeping in the same vein, Representative Warden, you are recognized for a motion.
I move inexpedient to legislate on HB 1143.
All right, so thank you. Seconded by Representative Boyd. Motion has been made and seconded. Representative Warden, you're recognized.
Thank you, Mr. Chairman. We didn't hear a lot of testimony on this one, and the bill frankly does have a couple good points to it, such as permitting an employee to opt out of a medical mandate. But unfortunately, there were too many fatal flaws in this bill. The term medical mandate is central to it, but it was not even defined well. It's too vague. And then this bill is the one that would require employer to pay severance equal to 2/3 of the value of the employee's total compensation, if you guys remember that. There were some questions about whether that includes bonuses or commissions for those people who are on full commission, and whether it would run alongside unemployment benefits. So with all those flaws, I think inexpedient to legislate is appropriate for this, and if there's a problem in the future, they can come back with something a little bit more refined.
Thank you. Would anyone else like to speak on the motion? Seeing none, the motion on the floor is inexpedient to legislate and has been properly seconded. Mr. Clerk, would you please call the roll?
Seaworth,
Yes.
Avalani. Callum,
Yes.
Mackey, yes. Love,
Yes.
Warden,
Yes.
Turcott,
Yes.
Prout,
Yes.
Boyd, Huff,
Yes.
Sullivan,
Yes.
Susie, Schultz,
Yes.
Cahill,
Yes.
Fellows,
Yes.
Schmidt,
Yes.
Toomey, Bouchard, Edgeston, Mandeville,
Yes.
Infantine,
Yes.
21-0.
Without objection to the consent agenda. I would like to address House Bill 1124, Federal E-Verify, and call on Representative Sullivan for a motion.
I move ITL.
Motion is ITL. All set. Wilson?
Yep.
All right, it's been motioned, it's been made, it's, by Representative Sullivan, seconded by Representative Susi. You're recognized to speak to your motion.
I think in a committee where we generally don't like putting additional mandates on businesses, this is unnecessary. We heard testimony over the errors that occur with the E-Verify system and could force somebody out of work for an extended period of time unnecessarily. And we've got an I-9 system that's effective, it works, and it assures that people who are not qualified to work are not allowed to work. So I think this is a bill that's unnecessary and potentially harmful. Thank you.
Representative Turcott.
Thank you, Mr. Chairman. I will rise in opposition to the ITL motion. I have to admit I'm a little bit conflicted on this because there are some pluses and minuses that go along with it. One of my very big concerns right now is the illegal immigration issue, and this, I believe, would have some effect on slowing that down. I do see the downsides, as Representative Sullivan spoke to. We don't like putting mandates on businesses. Once in a while, we have to go against the 100% rule. Nothing could be 100%, and for me, this is one of those. So I will vote against the ITL motion. Thank you.
Representative Schultz.
Thank you, Mr. Chair. I have a question for you. And by the way, for the record, I really want to be on this committee in the future, so next time, if I'm reelected, I'm going to put it down.
That's because we're the cool kids over
So
here.
see this as my warm-up, not just the bills I've brought to you. I'm wondering how many people signed in favor or against the bill. And I'm also curious to know, among those who testified, did anyone from the BIA or any of our business leaders address this? Because, and I will just make a point, it is definitely my impression, given how awful our current immigration visa status is, our businesses do not have enough employees to match the number of visas that we get in New Hampshire. And it is a huge problem. And as I understand it, and maybe I should let you answer the question, but as I understand it from my conversations with business leaders, especially in our tourism industry in the summer and in our tech sector, especially in the southern part of the state, this is enormously difficult. And anything that would be in the category of, quote, addressing undocumented immigrants in a negative way actually also hurts the existing workers that they do rely upon, and we actually do too, by way of eating the food or being in a room that was clean or using the software. I should have let you answer my questions first, though.
No worries. You're allowed to make your comments as everyone else have. In answer to your question on House Bill 1124, who signed up online, 93 opposed, 4 support, 1 neutral, and there were 6 My notes here, 6 individuals spoke against it. I believe there's only 1 who spoke in favor of it. Representative Seaworth.
Thank you, Mr. Chairman. I want to respond, and nothing against your comment. I think what you said, I heard from some of the public testimony that we had. I am concerned that some of those who testified against this bill did a disservice to their cause. As Representative Sullivan said when he made the motion, we do have a system that prohibits employers from hiring employees who are ineligible to work by federal law. Whether an employer uses E-Verify or whether they use the I-9 system, that does not change who is eligible and who is ineligible to work. And I was a little concerned that some of the people who spoke during the testimony gave the impression that we shouldn't pass this bill because they wanted more people who were ineligible to work to actually be eligible. And I just think that whether they believe that as a matter of policy or not, I don't think that's relevant to this bill. And I think it does a disservice to our debate on this bill to imply that that's a factor as to whether you should support or oppose this legislation. Thank you.
I personally support, oh, go ahead, Representative Smith. I didn't see your hand.
Thank you, Mr. Chairman. I think what we actually heard was in the testimony that there are people who are new to our country who are perfectly legal and ready to work here. We're seeing a lot of folks coming in from other countries looking for what New Hampshire offers, and they aren't in systems yet. They need to start working immediately, and running them through a second database, not just the I-9, but the federal database that keeps track of all of this. It takes time, and it's something that a lot of families do not have. My biggest issue with this is it's another mandate on businesses. Small businesses do not have personnel folks to do all of this work for them. This is intrusive in small business, and I really think that this is unnecessary because I-9 operates very well. Thank you.
Thank you. Representative Prout.
Thank you, Mr. Chairman. One of my big concerns with this is, I believe we had discussions around how practical it is to repeal this later if we find it's not working. And that once a business is required to sign up with the federal E-Verify program, by the federal regulations, it's unclear that they can actually accomplish that and withdraw from the system. And so the prospect that we'll be entering into something that we don't have a way to tweak or modify or change the scope of later is of great concern to me, and that's why I'll be voting ITL.
I support E-Verify, but I will be supporting the ITL. In the testimony, the thing that bothered me probably the most was the comment was made about how some individuals who are not legal to, and I guess you have to be careful, I have to use the right term, people that are not able to, what was the term? I don't want to say it wrong. Undocumented, thank you. Undocumented workers are treated poorly. They aren't paid well. They're in unsafe situations. So it behooves the fact that why would we want them to work here if they are undocumented and subject to poor wages and unsafe working conditions. So E-Verify would be a good thing. However, while we were sitting here, Mr. Berkey was just able on his cell phone to get flowers for his wife, make dinner reservations, check out flights and what they were going to cost so he could take her someplace nice. But we can't do that with the E-Verify system. It doesn't know a two-lettered last name. It doesn't understand maybe some situations where someone, their culture has 3 names. And that's ridiculous because Amazon can get something here tomorrow for anywhere in the country, and it seems. But we can't seem to figure this out. So while I do support the system, and I sure hope someday it gets fixed, and it was disturbing to hear that in states where it's required, a minimal 20-some percent, 30% of the people are utilizing it. So I do support some kind of a system, but just not quite this bill the way it's been presented. So, any additional comments? Representative Berkey. Don't. Come on, your wife is watching. She's expecting flowers. She's expecting flowers now when she get home tonight. Seeing no additional comments, Mr. Clerk, would you please call the roll?
Seaworth.
Yes.
Avalani. Callum.
Yes.
Mackey, yes. Love.
Yes.
Warden.
Yes.
Turcott.
No.
Prout.
Yes.
Boyd. Huff.
Yes.
Sullivan.
Yes.
Susie. Schultz.
Yes.
Cahill. Yes. Fellows.
Yes.
Schmidt.
Yes.
Toomey. Yes. Bouchard. Yes. Adjutant.
Yes.
Menaville.
Yes.
Infantine.
Yes.
20-1.
Without objection to the consent agenda. Oh, I'm sorry. Go ahead, Representative Sullivan. Yes, please. Yes, please. All right, it is now 12:30. We have gone through many of these bills. We have 5 bills left. They're going to have some debate. Who would like either just a 15-minute break or 30 minutes? Who would like 15 minutes and to go on? Who would like 30 minutes and then we go on? Okay, we're going to take 30 minutes. We'll be back here at 5 minutes after 1 to finish. Pardon? I'll give you a few more. I just figured maybe by this time the cafeteria wasn't going to be overly crowded, so you can grab something. Thank you. We're going to do 1352. Well, I'm going to talk to Love. I'm going to tell him it's 28 acres.
Well, but he was a professional fighter, and I don't know how appropriate it is for me to be a witness when we're executive out there, and so I didn't want to say too much. I know that we've had people who haven't shown up. I don't know why police chiefs have volunteer fire chiefs
much of a lunch, but.
I know, weird, huh? I know, I almost, Is he? Well, he's above it all. Yeah, he's not very smart. That's very disappointing. But he thinks he is, which makes it even worse. I'm really surprised that we were able to, to pass a few of those the way we did. I think they were just sacrificial votes. I mean, not pass, I mean kill. I try not to, it's run by a right-wing guy. Tony Shanella, he is, yeah. Oh, yeah.
What if you're the supervisor
very
for the shifts and you're the one who keeps the building?
Right. Screw you up.
Well, yeah.
How is Nicole doing?
Good thing she has a new job.
Yes.
And but she still is 2%
But I think everywhere would tell you, don't do that, have the information, and make everything explicit, and then follow it for everybody in exactly the same way. That way you won't end up.
She reacts more, which is a benefit to her sometimes, but right now it's not. And people don't have patience, yeah.
No, I do, but that's, I guess that's part of being.
Oh, I think it's terribly complicated anything that tries to compliance on PTO. Terribly complicated.
I think you have to learn patience. I think it has to grow. You know, she's one has to work on it.
I have 7 categories of time off right now.
The one thing she doesn't understand is
Sick time,
you come
vacation
from where
time,
you come
parental
from.
leave time that I just
I
had a
come
kid.
from where I come
Sick
from.
family
She
time.
does as well.
COVID-19.
And sometimes they just
COVID-19 is a
can't
family.
explain to somebody else about ourselves.
No, I don't know if I did. Well, maybe some. The COVID-19 ones I don't think were pandemic. Those ones they did because they wanted you to not even think about No, they wanted it above and beyond sick time, so you don't even worry about using your sick time balance. For COVID, really. Because there are people that actually longer and serve their sick time, and they didn't want that.
You've never experienced it, it's just part of who
It's
you are.
been interesting, the last couple of years, politics has gotten into this benefits policy. Another one is the being paid to go home. Suddenly, this last election, employers that we left were saying, hey, we need to pay attention. We want you to pay. That's all. We didn't need it. So, we have for years,
So is she talking to you now, or is she still in here?
Within a half an hour, everything's on. That's one of my stuff, you know, this way thing.
this year, I actually did.
Sit down and process it.
Well, I've been trying to get the people who are attacking her to stop.
It was, and that's what I
Online,
got so
on
hung
Facebook
up
and
on
Twitter.
this.
I just want them to stop with it. It's done. But they keep attacking her. At this point, I'm just an old white woman.
Businesses now,
I
we
should
need to
sit down.
suspend everybody. Don't tell them to do anything. We intend to.
And you know,
In some line, in the layoff.
Well, I'm not going to technical terms.
Right. And yes, it was, so.
I'm sorry?
You know what, I'm not gonna come back.
No, it's, some of the members of RAD who are after Nicole. I'm not sure what happened, but neither of them is going to let go, and it's really frustrating. Thank you for taking care of her. You're doing,
I'm getting shit.
you
And I got attacked in a meeting yesterday when I was one of the people who started this. It's so awful. I lost sleep. My husband is like, stay away from all of it. But here's what I was, because I know you're in it too. We can't feed this. We've got to starve it of oxygen. That's the only way it's going to work. All of us need to just stop talking about it, period. That doesn't mean we're not helping as we can. It just means we're not feeding it oxygen on social media.
if somebody says something, I respond. If they respond back to me and it's unkind, it ends.
I wouldn't even
I
respond. You're a target, I'm a target. You know, there's a little list they have. They say they're going to try to get people to run against us. Like, it's funny. And I feel like the only, we need help with creating receipts that are really, we need help.
They're looking for people to run against you.
I don't know if it is with you. we all are a little blind to something, but that this underlying thing way before was also anti-Semitism, is the way people were talking about Israel and Palestine. Who should care what other than I am definitely going to stand on the side of not being anti-Semitic. If they're forcing me to pick one, I support Palestinians. I'm not. Anyway, why should I have to use it? Like, who cares? You know, I was calling one of the folks. This is how I found out I was a
From day one, he could walk in, work a day and say, you know what, I think
Bonasucci's minimum wage bill. And
that was good
I was so upset.
He said, no,
I didn't end up going the next day for a bit here, which is very much not like pretty strong, and that's my issue, that will always get me out of bed and to a place. But she just told me all the things people had said and felt about me, because one of the things was excerpted from our private chat. And by the way, I don't feel safe in our caucuses anymore. I don't. You know, they did what they, whoever did it for a reason, and that's their, you know, Pentagon Papers moment, I guess. But I did not say anything denigrating about anyone. I just was referencing that before that incident, it shouldn't have happened, and she knows that. There was already an issue, and there was a separate issue. But because I said that, people are saying,
when I worked in New
I've
York
been
State,
told anyway by people, I'm a racist because I didn't just focus on condemning the N-word, condemning the whole.
they decided the
Well, I
company.
had said those things. I mean, I had said that. They said that's all you should have said, then you should have shut up.
Salaried employee.
Look, we were having a private conversation about, I was mad that leadership handled it poorly tonight.
That's how we're gonna
All they did was ask her one
Well,
question and
in
hang
a
up on
technical
her.
field,
I
it is.
think every
You're-
one of our caucus, even
You're
the
focused on
assholes,
your work
I'm not
product, so
saying
some
assholes.
people would just stay on
You
there all
should
night
be
working on
listened
stuff
to.
they're
If
into.
they say there was another piece of
And,
this, you should
You know,
listen
some
to
people
them,
would do stuff
period,
on,
end
and
of
a
story.
lot of people
You don't
put
have to
in
agree or
overtime
like, you
anyway.
don't.
Now you come
Anything
to
might
this minute, you
make
must
better
work
sense.
45 hours
I
a
don't know,
week.
how do you feel?
People
I feel
start
like you
clocking in and
disagree
out,
with me on
and
certain
that's
things.
it. If you want
Direct to
45
me.
hours a week and you're not gonna pay me, that's
I
all
don't-
I'm gonna do. So,
You have a unique perspective is all, and I'm curious. You once voted against the minimum wage, but I like you because you have a very insightful, I don't know you very well, so I'm not judging. Yes, and a Bernie supporter. He was a very smart supporter. On the floor, when it was the amendment to the 12. The first one, when it was a $12 bill, forget the deal, how we're talking. And it was my amendment to
I know a lot of people said it only can go through That's the problem.
well, and some do have, you know, you've got to be at the key.
Actually, we
You
should
step
go
away
15 and go right
for
to
whatever
12.
Well, you
reason,
know,
that's
California
a
just
great
is
thing,
going to
doesn't
18
count.
now,
Others
or at least
don't,
they're
others
working
it's
on
you
it.
clock in the morning, you clock
But
out in the
anyway, I'm
afternoon.
trying to, by the way,
So,
at the
Again,
behest of my
one size
husband
fits
and a
all.
few other
There's
folks
no
who are not
balance.
political,
Screw
to
someone.
just stop
So I was
just withdrawing from the
we had
drama.
Just don't let it be
a
personal.
woman who was back
It
in
is
the
a
aerospace
limit.
company.
When somebody calls you racist, what do you
It was a
say?
stress-related, serious one. She was in
I'm
the
gonna
hospital.
care and wanna understand why, and then I wanna fix it.
Don't care.
That's why
They're messed
they don't
up.
want,
So
they don't wanna let me
she
fix
knew she
it
was
because
something.
it's not about me. It's about, there's
And
like
imagine
this
the stress,
chapter by
knowing the
Kate
day you come
Fairclough
back into work,
who has been
they're
advising
gonna
me.
tell you you're laid
I
off.
was just told,
So
actually, all this
she
has been
was
about trying to leverage you
years on
to
disability
say something to
because
Nicole,
the mere
happy
thought
to
of
help
coming back to
with
work
Nicole.
and
And
immediately
when
being
Kathy's
fired
dying,
was too much.
really cares about Nicole and they spend time together.
But yeah, it was legit, but you know, we're all sitting.
I'm not gonna ask her. She doesn't want any bullshit drama.
And they
Like, you
decided
need to
that
leave me and
they
Kathy
just
out.
have to accept it. She never comes back, she's fired.
Okay.
And the rest, I mean,
I
it
do,
was a
yes.
big layoff, so the rest of us see, like, our friends lose their job, and she doesn't get laid off because
They love her.
she doesn't want to come to work.
Oh, interesting.
So, should we know the category of employees that was in the
I told them I'm hanging on by a thread. Now? Really?
Here's something.
You know, technically none of it is red. Oh, no! It's the bear. He's here. He's the bear. What's the bear? You know, Goldilocks. You're Goldilocks. He's daddy. By the way, I saw a comedian say, you know, Goldilocks is an asshole. You know, she found the comfy bed. Oh, this bed's too comfy. You know, she'd really just leave me.
And they've had that for years.
After all these years of
And
building
then-
that nursery.
Then I could take 8 or 12 additional weeks on the state plan.
Now, Goldilocks, she was sitting in his chair, and she found it comfortable, so that's the Goldilocks story. Yeah, that's, I'm sorry. But I'm surprised to hear you say, I just assumed, I don't know why I, back to red, I don't know why I assumed.
That was our-
anyone in Bernie
Yeah, the one in
support
Massachusetts is you basically, since I was specifically leave,
Somebody told me that,
employee benefit first.
I'm sorry, I don't know what we're going to ask.
Then,
Ask
the
me,
balance
she
of
was
the,
going to
to
be
the
out.
FMLA kind of 4 weeks.
Interesting.
Then I would start
I'm trying to
taking
make
state
peace with
plan, or
her,
just
but
take vacation time, or just
No, 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 no.
completely unpaid time off.
Say the same set of things over
Well,
and over.
Yes.
This is,
You haven't talked to her too?
wanted to ask some exact.
She said, I don't need to call myself a Colorado. I'm like,
One of the big
I wanted to
reasons
say it, I'm
this
just not that
insurance
person.
plan and the
But I
system
wanted to
is
say,
designed.
I'm not sure you're the one that
You
decides who
work
is
for
and
6
isn't.
years.
I think there's no committee.
On to sick.
I know people who didn't sign that letter, that were asked to. And I don't, at least one, I don't know. He did, and now regrets it because of all the animosity. And that should have never been public. All it's done is help Republicans at a time when our morale in the House is shit. And if you're listening and a Republican can't put in earphones, actually, I don't care. I mean, it's not like you can't tell. They know it. You know, what we need is not that bullshit. What we need are rallying cries and reminders of why we're in
Same
this.
issue with health
And
insurance,
not
right?
everybody
Go
is
to BS
flustered
and
or
then
sucked
whatever.
into the drama that enough of us have now,
Whatever the reason.
and enough of us have been
Mine's
attacked.
probably
And the number
I called the benefits office and I
complaints that one member files against another, and I'm embarrassed to say, I have to do
because
one.
there's no insurance
Again,
company.
because someone tried
It's
to
just no
hit
administrative
Kevin's
legal
car.
action.
Anyway, it's awful. Actually, she's not a Democrat. Yeah, tried to horn in. I was doing what the state
They're a process,
asked me to do.
but yeah, the company's self-insured, so
And
they.
she did that where, you know, like if you've ever driven in a big city and packed
Oh,
all the time.
yes,
It's like, say, here's
Well,
the
it's also,
SUV
MIT
that was in
goes
the proper line.
to an extreme with that, which is that.
Here's the juror.
paramedic
Here's me.
which
I'm right here.
is tax dollars.
I'm following the person
So the
state
in-house
trooper
everything.
told me to. She's trying to touch both bumpers. And it's
Well,
not
they
my
do
car,
in-house
it's Kathy Rocker's
most
car.
companies.
And then she mouthed the word bitch, stuck her tongue out at me like Miley Cyrus and flipped me the bird.
In aerospace, if
How
you
did
get
they
hurt
expect
work,
us
you
to
go
work
for
on
the
it?
med ball.
I don't know, but
They
it's
take care of
stupid.
it. So
I feel
there's
like
no
though,
question of,
get
well,
better
who
treatment
do I
than
go
from
see and how do I file a claim?
Republicans
You
on the
just
whole
walk down
than
the
I
hall
do
and
from
go to the.
Democrats. They're manic.
Yeah, it's so much easier.
There's a MIT medical satellite office, just the street from my work. So it's like if I thought I
They're
had
nice
sick
to me,
about this
you know?
before, I just call up
Even though
and
it's
said,
moving.
I
But,
want
you
to
know,
start
that's
check.
part of the
Like,
fun
all
of
right,
it.
give me your 5
I'm
minutes,
never
I'll check.
trying to, I don't need anything from them. I'm not gonna convince them to
And actually,
be with me on
Well,
social
Once in a while
issues.
it works. Not the big ones, but once in a while it works.
it
You
used
know
to
what I
be
mean? Like,
my insurance.
I don't need
It
anything
used to
from
be
them, it makes it easier.
It was no
Anyway,
copay,
it's
just
been a
full
hard
coverage.
2 or 3 weeks.
No.
hospitals have an exception. That when they do workers' comp claims, you can just do it in the hospital. That was disgusting. But I would think there's more cases of that. Exactly. I wrote to the chair and the teacher, and I said, this is Right. But our system forces it to all go through the insurance. And it seems like at a minimum, it's a lot
Members of the committee, I will apologize in advance. I spilled chili on my shirt. I didn't get a chance to eat downstairs, so I'm going to secretly try to have a bowl of chili here as we're doing this. I apologize.
Good for you.
Yeah, I know. My mom is watching. She said, get your butt upstairs. All right, we have a number of bills. I'm gonna go in numerical order here to help the clerk out. The first bill is House Bill 1053, and I call on Representative Mark Warden for a motion.
I move inexpedient to legislate on HB 1053.
Motion is inexpedient to legislate by Warden, seconded by Avalani. Representative Warden, you're recognized.
If y'all may recall, this bill would have required an employer to pay wages at an hourly rate equal to time and a half to any employee if the employer called them into work hours not previously scheduled pursuant to the employer's normal scheduling procedure. So it was a little bit unclear what the normal scheduling procedure was, and of course this is yet another mandate on employers who have all sorts of different arrangements depending on the industries they're in and the timing and the shifts and the size of the company. We did hear from a number of associations representing employers and businesses who were opposed, and I have to agree with them and their testimony on this one. Let's dispatch it.
Thank you. Would anyone else like to speak? Representative Sullivan.
While I kind of like the idea of the bill, I think we heard enough testimony over how difficult it would be to implement that perhaps there's a way to do this, but this isn't going to be it. So I would support the ITO.
Thank you. The clerk just found his paperwork. Give me a second here. It was moved by Warden. Seconded by Turcott. Yes, one of the issues I had with it is, well, it seemed to have a good concept, paying time and a half for someone who was called into their normal schedule. Almost felt like the employer, it's voluntary time. You know, if you're not scheduled to come in, you can't come in. You're not going to come in. You're away. You have plans. You're doing whatever. And trying to entice someone with a time and a half to possibly give up their plans, again, we always talk about trying to be fair with the workers. I just thought it was a dichotomy. But anyway, that being said, with a motion on the floor is inexpedient to legislate. It's been properly seconded. Discussion's been had. Mr. Clerk, would you please call the roll?
Seaworth.
Yes.
Avalani. Yes. Callum.
Yes.
Mackey, yes. Love.
Yes.
Warden.
Yes.
Turcott.
Yes.
Prout.
Yes.
Boyd. Yes. Huff.
Yes.
Sullivan.
Yes.
Susie. Yes. Schultz.
Yes.
Cahill.
Yes.
Fellows. Schmidt.
Yes.
Toomey. No. Bouchard. Yes. Adjutant.
No.
Mandeville.
Yes.
Mr. Chair, I'd like to change my vote to no.
In a moment, please.
Inventine.
Yes. And now Schultz has requested to change her vote.
Okay. Uh, 18 to 3.
Is there any objection to the consent agenda?
Objection.
Okay, objection will be a minority report.
Yes.
Very well. Good. Next bill, House Bill 1089. Relative to enforceability of non-competes.
Mr. Chairman? What? Huh?
You don't want to
Okay.
You recognize it, Representative Turcotte.
Okay.
Oh, were you supposed to do that?
I thought I was.
Write it down as me.
I've already written a blurb, if that helps you. Okay. Yeah, I think
ahead,
we're
go ahead, take
confused. I would like.
So which one would like to be recognized? Representative Seaworth, you're recognized for a vote.
Thank you, Mr. Chairman. Sorry for the confusion. As I mentioned earlier this morning, this is one of two bills that dealt with I think, the same problem, this intersection between the COVID vaccinations and non-compete agreements. For those of us who were present for the public hearing, I think we had during that discussion, there were some concerns about the original language. And, Mr. Chairman, I would like my motion to be to offer an amendment.
Right. Your motion is moving amendment number.
Amendment number 0376.
Seconded by Representative Huff.
I kind of missed that. All this confusion. And for members of the committee, I don't know if I mentioned this to all of you, I sent an email out with a copy of this amendment earlier this week, if you got it electronically. There are also some copies on the table,
This was-
which the audience could get.
It was also handed out to each individual member at our last meeting.
And I will speak to this amendment when you're ready.
Just want to make sure everyone has a copy of the amendment, knows what we're talking about. Representative Fellows and Schultz, you have? All right, Representative Seaworth, you recognize. to
Thank
speak
you.
on the amendment.
So as I said, in the original testimony, I think there were a number of questions, some concerns about the original language, and we offered that we'd work with the sponsor to come up with some better language. I actually did work with him directly as he was drafting the amendment that we now have before us. And I do think this makes the bill better. I think this makes it a bill that we can get bipartisan agreement, that it will be a positive thing for New Hampshire workers. Briefly, I'd like to go a little bit into the context of this because I think it is important. The chairman has explained to us in an earlier meeting that this is an area, the area of non-compete agreements, that a few years ago, the New Hampshire State Supreme Court came down with a ruling that essentially said that a non-compete agreement cannot take away an individual's right to earn a living. And so that sort of hemmed in the scope, the possible scope of non-compete agreements from what maybe someone like me remembers from the 90s, where a lot of companies would just throw these things at you and they'd be very limiting. And frankly, a lot of people said, well, most of that's unenforceable anyway. The Supreme Court ruling delineated some limitations to that. And then subsequent to that, we passed a couple of laws that further limited it. In 2014, we passed a law that required disclosure. So you cannot enforce an agreement unless you've provided the full language of that agreement to an employee before they agree, before you bring them on as an employee. Then in a couple of years later, and it was, Mr. Chairman, you were not in the House, but you came to us as a knowledgeable citizen and helped us get the language right. We passed another bill that said that non-compete agreements were unenforceable for low-wage employees. And we defined in that law what we meant by low wage. It was up to double the federal poverty level.
And in additionally, we passed another more narrowly targeted law for the medical industry to deal with some very specific issues they were having there. So that's the context in the state law. We've kind of walled in when you can apply a non-compete agreement. As the chairman mentioned in an earlier session, it's kind of at a good balance now. During the testimony, it was explained to us that even the original bill language, the sponsor thought it was merely restating what case law already applied, and in this case he cited the federal law. And with the federal law, there's this term, material change to the terms of employment, that will result in nullifying a pre-existing non-compete agreement. And I just want to be clear, I am not an expert in this. I'm not a labor lawyer. Please take everything I say as someone who has tried to research this on their own. But if I understand this, the example that I found was, so someone's hired and for a nice salary, and part of that is that they sign a non-compete agreement. And you may make the decision that, yes, for this amount of money, I'm willing to potentially sign away my rights for a couple of years. Then later, as you're employed, the employer comes back and says, you know what, we're cutting your salary in half. Well, that no longer looks like a good deal, and the courts have held that that will nullify the agreement that you signed under one set of conditions that now no longer apply. In this amendment, I tried to change the focus of the bill from this COVID vaccination to that particular issue. And it starts out talking, when there is a material change of employment, then that requires that you either renegotiate any non-compete contract that's already in place, or the previously signed non-compete no longer applies. I did, working with the sponsor, we did leave in the language about, we expanded it a little because one of the questions was, you know, what did it exactly mean? So it now says, I just lost it, about medical intervention, medical testing and vaccination. We left that in there. That was the intent of the original bill. Again, the sponsor said he thought this is already the existing terrain based on case law. I would agree with that, and so I don't think it changes anything to make that specific and comport with the original intent of this bill. And I would say in the broader sense, this expectation that a material change would nullify an existing non-compete, I think it is, practically speaking, how things are. We're not really changing the way, the legal environment surrounding non-competes, but what we are doing is, in some cases, the Department of Labor will now be able to get involved in issues that formerly would require a civil suit and going to court. And I think that's consistent with the bills that we've already passed in this area. The disclosure one comes to mind, and I think it's consistent with what we like our Department of Labor to be able to do in cases where employers and employees have a dispute. So I'll now hear if I'm right about that, but I hope that this amendment changes the bill, if you didn't support it before, to be something that hopefully everyone can agree with. Thank you.
Thank you, Mr. Chairman. I'd like to ask a question on that, if I could. And that would be, the new language delineates medical testing, vaccination, and medical intervention as shall be considered a material change. Is it the intent of this language that it is not exclusively for those three items, but it would actually apply to any material change.
And if I may answer? Thank you, Mr. Chairman. And in fact, the Deputy Commissioner asked me the exact same thing when I asked him to review this. And the way I read this, it is in addition. So it's any material change, and then just make sure to clarify that these things are included additionally. Or, well, and as I said, I think they would, whether you state it or not, I would expect those things to be included, but this clarifies that, so there will be no question.
Thank you, Mr. Chairman. Just a question for Representative Seaworth, if the chair would allow. Yes. Line 12 on the amendment, at the will of the employer, could you just define what that means?
So the way I understand this, and I did speak with the sponsor before he drafted the amendment, if it's the exact wording he came up with. So if one might wonder if I am asked to sign a new non-compete because there's been a material change in employment, and I say, you know what, I don't find these new terms acceptable, I won't sign. Can the employer say, because Seaworth didn't sign, he's quitting, and whatever implications in terms of a lawsuit that might imply? And the intent of the language is that the employer is required to come to a new agreement regarding a non-compete if, in fact, that non-compete is a condition of employment. It puts the onus on the employer to come to terms, and it's, to my mind, it's a bit of a bone. We heard about this regarding another bill, a different subject, but in some cases, these labor disputes will end up on two different tracks with the Department of Labor. The fact that the Department of Labor will be involved with this does not take away your right as an aggrieved employee to file a civil suit and attempt to recover whatever damages are appropriate. The Department of Labor, on the other hand, is dealing with the employer. So that same employee might file the suit and then call up the Department of Labor to report the problem, in which case the department would give a warning to that employer. You know, you're forcing people to sign contracts that you can't have them sign. They might work with them to try to get that situation corrected, and if the employer still continues to be a problem, there might be fines levied against them. But in most cases, the Department of Labor isn't going in and finding corrections that will help the employee. And so part of the reason why I suggested language to this effect is it does give a little more to the employee who's has a problem with this process as they engage in whatever they're going to do to try to get things right with their employer. It gives them a little more clarity that the fact that they didn't sign this new agreement is not quitting, it is a termination by their employer.
Given that it's at the will of the employer, would that qualify for unemployment?
Interesting question, and I'm not going to try to be definitive in this. I would actually like to hear it from the experts from this. I'll give both sides of the story. One is that is what this implies here. The other side of it is this is not in the employment securities law. This is in the wage and hours law. It's specifically under the non-compete section. So would employment securities consider this law outside of theirs to be binding on them, that would be a question that I'd look to the department for a definitive answer.
Thank you, Mr. Chairman. I have another question for Mr. Seaworth. So am I correct in understanding that an existing non-compete agreement would require, that did not include all the possible things that could happen in the world, such as a pandemic? If for example, you operated a medical practice and maybe your doctors agreed to a non-compete and they had to get certain vaccinations and treatments, but you didn't list all of them, and something new showed up with a new Greek letter or name. You'd have to get a brand new non-compete. At that point, you couldn't just have a broad non-compete that says you'll get whatever the CDC recommends. That was for you. Yes.
And thank you for that question. I do think it's a good question, and it would depend on the individual case. So there's actually two things that apply here. There's your terms of employment and the terms of the non-compete clause. And either of those could be as narrow or broad as the employer wants them to be. So yes, in a hospital, it might well say a condition of employment is you get all the vaccines as recommended by the CDC, and an employee knows that going in. As that shrinks or grows based on what's going on in the world, that hasn't changed, to my mind, again, the terms of employment. On the other hand, it could be written another way. They could be very specific about what the terms are, and a change to one of them would be considered then a material change. So it doesn't exactly answer your question. I think it could work both ways, and it would depend on the details of the agreement with the employee and the non-compete agreement.
Follow up, Mr. Chair. Would it be reasonable to request some sort of amendment exempting medical personnel?
At this point,
you're off.
At this point, there's no amendments. This is an amendment to the bill. This is the only bill in front of us. This is the only amendment in front of us today, and we will be execing today. So in the future, a possible amendment, possibly if this passes in the Senate, might be appropriate, but I'm not going to hold executive session today and wait for an amendment. Representative.
Thank you, Mr. Chair.
Representative Seaworth.
It's okay if I respond too. So part of this, I'm presenting the amendment, but I'm thinking about the sponsors of both of these bills. And I think, but I don't know, that at least one of the bills, maybe both of them, were concerned about the situation for medical workers. That what was happening is people were finding that they had these new mandates imposed at a medical facility that they disagreed with. And so, fine, I'll leave and go work somewhere else. Oh, but you can't, because there's this non-compete agreement that doesn't let you leave and go somewhere else. So I think, at least for some of the sponsors, and as I said, I can't really speak for them, the issue of the medical worker is central to what they're trying to address. And remember, this isn't a broader issue of can you fire someone or can you require an employee to do certain things. This is addressing the issue of the non-compete agreement, and when can you tell someone, you know what, you can't go across the street and get another job even though we're basically forcing you out the door.
Representative Mandeville.
Thank you, Mr. Chairman. I'm going to vote in favor of the amendment because I think that's the best practice when, as here, it is clearly an improvement over the original, even though I will oppose the bill as amended.
Thank you. Representative Fellows.
Thank you, Mr. Chair. I'm just wondering if there's the amendment uses the term material change in terms of employment. Is that defined anywhere in statute? Because if it's not, it would just apply to what it says here. I tried searching, I couldn't find it. But that isn't, I'm not saying that it's not there just because I couldn't find it.
I think we may have an answer for you, Representative Turcott.
I think material change is what they would call a legal term of art. I think you would find that in a term that attorneys use in writing contractual language and that sort of thing. It may not be in the RSAs, but material change is something attorneys use quite frequently.
Representative Cahill.
Yes, just to Mr. Turcott, would that term of art be because it's kind of vague and not succinct?
There are a lot of legal terms of arts that are intentionally written that way, so I would say that could be exactly the point.
Representative Seaworth.
If I may too, Ed, I think that's, Representative Turcott is exactly right on the legal side. I think we also can find cases in the Department of Labor where we're relying on them to look at the individual situation and the details of the case and intelligently decide, well, in this case for this employer and this employee, does that change meet what we think is a material change to the terms of employment? And I think it would make the bill worse to try to define that at the RSA level because we really want the Department of Labor to be doing that analysis on a case-by-case basis. And I think their process of adjudicating disputes between employer and employees shows that they're well suited to make those kind of decisions.
I have a question for the Vice Chairman. I'm going to outline a few different things here and then ask you a question. Lines 8 and 9 clearly state, if an employer makes any material change to the terms of the employment for any employee, any existing non-compete agreement shall be enforceable against such employee. Okay, pretty clear. Then you get down to this line 12, new requirements for medical testing, vaccination, or other medical intervention established by the employer as a condition of employment. Well, OSHA requires people that remove asbestos and lead paint to be tested at the beginning. It's called a base test. And they test them every X amount of period because they want to see if they've ingested a certain level of either asbestos or lead. And if they do, then they say, okay, you got to back off doing this because you're ingesting too much of this somehow. I was required by my employer to receive a vaccination when the legislature asked me to go abroad because of the country we were going to. So keep those things in mind. Don't even think about COVID because COVID vaccination is not a vaccination by definition. So it's not even covered here. Then you go down to this last three lines, 15, 16, and 17. So up here you say these non-competes and material changes, you're out of your non-compete. But then you say any other employment agreement, including confidentiality, disclosure, trade secrets, intellectual property, whatever, are full force and effect. Most of these agreements are multi-paragraphed. One is a non-compete, one is a non-disclosure. Okay? So I need to make sure that no matter what material change, whether OSHA requires it or whether something else, that when we finally get down to all this really important stuff, trade secrets, intellectual property, customer lists, all that other stuff, is still protected.
And that's my cue. And yes, that was, when we discussed this in public testimony, that was a key, those that seemed to be leaning towards supporting the original bill, that was a key component of their support, that this wasn't broadly just nullifying any contracts that employer had with employee, but that all these things would be exempt. So that language has been left in. I think it's the original language as the bill was submitted. It was certainly my reading of it that it retains the original force, that it's making clear that all of this only applies to the non-compete portion and does not affect any of these other things.
Very well, thank you. Are there any other questions or comments? And just so you know, when an amendment's brought to the table by any member of this committee, it is appropriate to ask questions. So that's all well and good. So don't feel concerned about doing so. Seeing no other hands, we have a motion on the floor of, we have a motion to pass amendment number 2022-0376H. Motion's been made, seconded, discussion is complete. Mr. Clerk, would you please call the roll?
Seaworth.
Yes.
Avaloni. Yes. Callum.
Yes.
Mackey. Yes. Love.
Yes.
Warden.
Yes.
Turcott.
Yes.
Prout.
Yes.
Boyd. Huff.
Yes.
Sullivan.
Yes.
Susie. Schultz. Cahill.
Yes.
Fellows. Schmidt.
Yes.
Toomey. Bouchard. Adjutant. Mandible.
Yes.
Infantine.
Yes.
21.
The amendment has been passed. The bill is open to further amendment. Representative Seaworth.
I'd like to make the motion ought to pass as amended.
Motion on the floor is ought to pass amendment is seconded by? Seconded by Representative Avaloni. Is open for discussion or questions. Oh, you need to speak to your motion, I'm sorry.
And not to belabor the point, as I said, I think this amendment vastly improves the bill. I think it changes it from a political hot potato to something that actually protects workers' rights. In the past, this committee has had some concern about non-compete agreements and over-application of them, and this provides one more protection to a worker who feels trapped by an inappropriate non-compete agreement.
Representative Mandible.
Thank you, Mr. Chairman. I will oppose the ought to pass on HB 1089. Some of the points have been discussed already. I wanted to wait till we were talking about the bill before I weighed in on them. The question of what a material change is certainly is a concern to me. As we all know, when lawyers are looking at legislation that might be unclear, they will look at legislative history. That will include Representative Seaworth's reference to the case that defined or mentioned material in this respect. They'll refer perhaps to Representative Turcott's description of lawyerly work. They'll relate to, refer to the plain meaning of it, all of which could be in conflict with each other and will create potential additional hurdles in terms of the ultimate resolution of what is a contractual right being one for a non-compete clause. Where this bill talks about there being established new requirements, a point to which I think the chairman was referring, regarding medical testing, et cetera, while there might be questions about how that would apply, at a minimum, it would also serve, in my view, to discourage the creation of new requirements that would respond properly to emerging circumstances, which would create another problem for this bill. And finally, I would note, in my opinion, that the place for dealing with overreach or other improper applications of non-compete clauses are in the courts, not in the Labor Department or by way of statute. This being a contractual arrangement between parties as they entered into an agreement. Again, there's a lot of protections for low income persons and otherwise in pre-existing legislation. There's the concern that I think both private parties and legislators have with regard to how much protection there can be for such things as confidential information, customer lists and the like. Obviously, as the chairman's pointed out, there are other aspects of non-competes, but they can cover the distribution of documents, for example, but people bring with them pertinent information, important information, and the legislature shouldn't be, in my view, intervening in that respect. So for those reasons, I oppose this legislation.
Thank you. For the record, since you brought it up, Black's Law Dictionary defines material change as a representation relating to matter which is so substantial and important as to influence the party to whom made the change. Whether that helps or not.
That's extremely definitive, right?
Yes, of course.
Not subjective at all.
No, no. Representative Mandeville?
Sorry, but
since I uttered,
as we both know, in the insurance industry, it is defined to mean anything that would change the rate or the decision of the underwriter to accept or reject a risk. That's a fairly more narrow definition.
are there any other comments? I'm just contemplating whether I'm going to say something or not.
Okay, take your time.
I'm very reluctant to mess with non-competes. That's why people are going to non-piracy agreements. I don't care if you want to compete. If you take something, you got to pay for it. That being said, the motion on the floor is ought to pass with amendment has been seconded. Are there any additional comments before we go to a vote? Seeing none, Mr. Clerk, please call the roll.
Seaworth.
Yes.
Avaloni. Yes. Callum.
Yes.
Mackey, yes. Love. Yes. Warden.
No.
Turcott.
Yes.
Prout.
Yes.
Boyd. Yes. Huff.
Yes.
Susie. I'm sorry, Sullivan.
Yes.
Susie. No. Schultz.
Yes.
Cahill.
No.
Fellows.
No.
Schmidt.
No.
Toomey. No. Bouchard. No. Adjutant.
Yes.
Mandeville.
No.
Infantine.
I got to break the tie, huh?
It's not a tie, no.
Yes.
13-8.
Motion passes. I expect a minority report. House Bill, next on the list is House Bill 1094 relative to employee work schedules. Just hold off a second before I call on someone. We'll get the clerk settled.
All set?
Call Representative Turcott for a motion.
Thank you, Mr. Chairman. I move ITL on HB 1094.
Motion on the floor is inexpedient to legislate, made by Turcott, seconded by Avalani. Representative Turcott, you're recognized to speak on your motion.
Thank you, Mr. Chairman. We heard much testimony from business industry. They were unanimously opposed to this bill. A lot of the issues dealt with businesses that were influenced by weather conditions. One individual talked about the paving industry. We had Commissioner Jasper talk about the agriculture industry. Again, they were all in unanimous opposition to this bill. There were also a lot of issues with the bill itself, mechanical issues. Picked out employers with 10 or more employees in the state or 2 or more locations. I had a question on that is, okay, if you have 2 or more locations and you only have 2 employees at each of those locations, are they still required even though the total is less than 10? There's just a lot of things in here that just makes this bill unworkable, and I recommend ITL on it.
Thank you. Any additional comment? On the last bill, I talked about an incentive, time and a half, and in the lines 14 through 16, they talk about compensating someone 1.5 times their rate if they're made to work in their rest period. Well, if you're tired at regular time, you're going to be tired at time and a half. And it doesn't seem to make a lot of sense. Any additional comments? Representative Avalani.
Thank you, Mr. Chairman, and for bringing that up, you would also violate Section 1 on page 2, and you would have a $50 fine if you made somebody work on their day of rest.
So I have to pay them, I pay a fine and I pay them time and a half?
Right.
America's a wonderful country. All right. Anything else? Yes, Representative Sullivan.
I think this bill came from a well-intended place, but it just too unworkable, too many problems, and I really don't like it when somebody puts 2 completely different issues in one bill, because you might like one but not the other, and it should have been 2 bills. But besides that, I'm going to oppose. I'm going to support the ITL.
Any additional questions or comments, excuse me? Seeing none, motion is on the floor. It's been seconded. We've had proper discussion. Mr. Clerk, would you please call the roll?
Seaworth.
Yes.
Avalani. Yes. Callum.
Yes.
Mackey, yes. Love.
Yes.
Borden.
Yes.
Turcott.
Yes.
Prout.
Yes.
Boyd. Huff.
Yes.
Sullivan.
Yes.
Susie. Yes. Schultz.
No.
Cahill.
Yes.
Bellows.
Yes.
Schmidt.
No.
Toomey. Bouchard. Adjutant. Mandible.
Yes.
Infantine.
Yes.
18-3.
Is there any objection to consent agenda?
Objection.
So noted. There will be a minority report. We have three more bills ahead of us. We are not allowed to add any other bills today because it was not in the calendar. So even though we have another bill that's ITL by the sponsor of this committee, we cannot hear it. And Representative Sullivan needs to be somewhere at 4 o'clock, so we're trying to adhere to our schedule of getting out of here in an hour or so. The next bill on our agenda, Mr. Clerk, is House Bill 1251, prohibiting payment of sub-minimum wage. And I call on Representative Turcotte for a motion.
Thank you, Mr. Chairman. I move HB 1251 ITL.
Is there a second on the motion? Representative Huff seconds the motion. Motion's been made and seconded. Representative Turcotte, you may speak to your motion.
Thank you, Mr. Chairman. We have seen over the years, I don't want to go as far as say dozens of these similar bills, but many, many, many times we've seen this bill come, or variations of this bill come before our committee. I always like to point out two instances where politicians and bureaucrats have gotten in between the employer and the employee relationship, and this is the example I always give. One of them is, I guess it would be about 4 years now, Maine politicians decided they knew it was best for the employees who made tips and in the service industry, and decided they would do a similar bill and institute a minimum wage for those individuals. Those individuals soon found out that they were actually making less per hour than they were when they were being tipped. They formed an association, and they got the Maine legislature to overturn what they had just passed the previous year back to the other way. My second example is the last my last term here, when we had a similar bill. I won't say exactly, but similar. We had an individual testify, an owner of a pub in Dover called the Seventh Settlement. And he came here in an attempt, he wanted to be one of the first to implement a straight across-the-board $15 minimum wage for all his employees, whether you're a dishwasher, you were a server, you were a bartender, didn't matter, everybody got $15 an hour. My wife and I used to frequent that pub. It was excellent. As soon as they implemented this, guess what happened to service? It went downhill. Less than a year later, they shut down the restaurant, and a short time after that, they had to close the entire establishment. We've got a very good system. We've heard from individuals in the service industry already that the average tip minimum wage is somewhere up around $20 an hour. I know for a fact, because I have a son and a daughter who both worked in that industry, that number can far exceed $20 an hour. And can be almost amazing how much individuals can make as servers or bartenders. So for all those reasons, we've got a system that works now. We don't need to be changing it, and I recommend ITL.
Thank you. Representative Sullivan.
Thank you, Mr. Chairman. I am going to oppose the ITL. And I want to also correct one misconception. This bill does not ban tips. This bill provides for tipped workers to earn at a minimum the true minimum wage. They would then earn tips on top of that. I know that a lot of restaurants are struggling to maintain their workforce. Some of the restaurants I like to frequent are closed on some nights of the week because they don't have enough staff. So I think this would assist with that problem. You would and frankly, there are quite a few restaurant owners that have seen the light and are already paying people well over the current minimum wage. So even though they earn tips on top. So I support the concept. I will oppose the motion. Thank you.
Thank you. Representative Schultz, followed by Stewart.
Thank you, Mr. Chair. I will reiterate that I did write this bill with input, and I did recently work for an organization that was fighting for ditching the sub-minimum wage at the federal level. I did not earn any money to do any of this work, but I just want to be upfront about that in case anyone has any concerns. So there is the caveat. There are actually 8 states, to counter the the state of Maine argument, 8 states who have ditched the sub-minimum wage for all of their workers. It has been great for them. They include the super woke states of Nevada, that was a joke, by the way, Nevada, Montana, Minnesota, Hawaii, Oregon, Washington, Alaska, and California. And by the way, California is now considering an $18 minimum wage, which I find interesting. The Darden Corporation board chair, in a call with investors, said, when asked about this movement to ditch the sub-minimum wage, said actually the restaurants in those states were better. So keep that in mind. And if I go any further, I'm probably just really repeating my testimony. I just want to make the point, though, too. I just emailed you, if you have a smartphone or currently refreshed device for your official email. There are instances since we met actually one of them may have been in the news. We had a former restaurant worker testify that in fact she had not been paid what she thought she was supposed to be making, not even just the tips, but even the base wage, and it was very confusing. And then I realized later that I hope he doesn't. Representative Seaworth was talking about the same restaurant and very dismayed with their business practices. Also this past week, it was in the news, one of my favorite restaurants here in Concord held back $62,000 worth of tips that are owed to those workers. I know that the majority of restaurants in this state are wonderful, with great business practices. They probably treat their employees well, and it's certainly a tough time to be a restaurant owner or bookkeeper. I'm not naive to that. But this is an antiquated system from the Jim Crow era that really has to go. And we were smart about it when we ditched the sub-minimum wage for workers with disabilities. This would be a similar advancement in just doing what is the right thing, in my opinion. But even financially, it's better. But I'd like to make a suggestion. Knowing that there are 2 recent really awful stories, and knowing that this is a complicated time for the restaurant industry and for workers, would you be open to interim study on this topic, on this bill? Sure. And of course, someone making the motion, ITL, could withdraw the motion as well. I'm just throwing this out there because it does affect, well, at least 2 of us. This is in our district, the issue that's growing. And I believe that the confusion around this issue for even restaurant owners and workers, I think that, you know, if it's not going to pass, I do think we should look at pay and today's market. And also I'll add, there are some servers, tipped workers who do make great money. They tend to be at the higher end restaurants. They tend to not share those tips with back of the house. Plenty of our restaurants do not do that well. I wish they did. This wouldn't, you know, then I doubt anybody would have any problems with the way things are going. But we need to level the playing field, because this type of law would in fact not, the restaurants who have the easy ability and flexibility are in competition with the mom and pop places. And if we don't level the playing field, it actually hurts the entire industry. And as much as I like the free market and Adam Smith and all those analogies, our free market doesn't always account for greed and misunderstanding. You know, for those of us who see not a worker shortage, but a wage shortage or a benefit shortage, this is definitely one of those issues that deserves discussion, because it ends up hurting our small businesses, the mom and pop restaurants, the most. And spoke more than I meant to, but I just wanted to make the case that you could withdraw the motion and go for interim study, but I respect the chair and the motion that is on the table.
Thank you, Mr. Chairman. I wanted to point out, and it does fit in with the immediately previous comments, there are two issues here. One is the policy, and we've had bills addressing this policy before, and there's a policy debate that people in this room come on one side or the other. I'd like to also focus on the specific language of this bill. During the testimony, there was, I heard a lot of confusion. I didn't hear the answers. This takes the 27922, what's a paragraph in current law, and replaces it with a sentence. And I saw a lot of people wondering what exactly that would do. I mean, obviously, it's intended to address the tipped wage. But what else does it do when all that language just vanishes from the books? And so for that reason, I appreciate the policy discussion, but I would also warn that I haven't seen any amended language to address that. I haven't heard answers as to exactly what the implications or fan out of this is. So I would caution the committee, those who might advocate for an OTP from that angle. Thank you.
Thank you, Mr. Chairman. One of the issues that was brought up with the sub-minimum wage is under no circumstances, if you're a server, even though there's the server minimum wage is down in the $3 area, under no circumstances can a server never get paid less than $7.25 an hour, which is the federal minimum wage. So to say that somebody can make $3 and whatever the number is, 23 cents or whatever it is right now, that is not supposed to happen. If it does happen, then the employer is supposed to make up the difference. Yeah, we have seen a couple of instances in the news recently about a couple individuals. Those were perfectly handled by the DOL. Exactly what they're supposed to be doing. They created the settlement. As to supply and demand in the free market, which I espouse frequently, it's not an analogy, that's economic principles. That's free market does work and supply and demand does work. Thank you.
Representative Hoff, and then I'd like to speak, and then I'll call you again, Representative, and then, okay. All kinds of hands. It's all over the place. Representative Hoff, and let the people who spoke first. Representative Hoff, Representative Adigent, and Representative Schultz.
Thank you, Mr. Chairman. I was just pointing that your microphone wasn't on.
Oh, so that was an easy, quick one.
Thank you, Mr. Chairman. I don't want to specifically direct this question at Representative Turcotte, but it was something that he mentioned. Yes, it is true that a server cannot be paid less than $7.25 an hour. I guess I'd ask a question if anybody wants to answer it. Then, if that's the case, what's the point of having a sub-minimum wage? If a person cannot legally be paid less than the minimum wage, what is the purpose of having this arbitrary number at $3 that the employer has to make up the difference to anyways? It just seems like putting a hat on a hat. I can't really square that as to why it would be necessary to keep a sub-minimum wage if they can't be paid less than the federal minimum wage.
When I speak, I'll give you an answer. Representative Toomey?
When I was younger, a long time ago, the customary tip was 10%. Over the years, that evolved, and it became 15%. Now it's 20%. More of the responsibility to pay a server falls in the customer's hand now, and this doesn't stop tipping. All it does is maybe create a mechanism where the employer would be more responsible for paying the employee and the customer less responsible, but still responsible. Thank you.
Representative Cahill, did you want to speak? You got to get me some of those the mirror things so I can see you guys on the other side. I want to get to everyone first before I get back. Representative Avalani, Representative Schultz after.
Thank you, Mr. Chairman. We were, the Representative Schultz has sent us the,
yes, I read it.
You read it from the patch?
Yes.
It is illegal to split tips with your supervisors. It's also illegal to split tips with the back of the house. It's also illegal to split tips or withhold tips from your employees. So, trying to redistribute the tips to other members of your employees who do not earn them would be a direct violation of state and federal wage laws. So we can take that. If anybody wants to read the tip regulations under the Fair Labor Standards Act, it was just rewritten in April, and any responsible business owner that has a restaurant would know that you can't take your employees' tips.
I did speak to the Department of Labor about this, but I'm going to let Representative Schultz speak, and then I will tell you about my conversation with the Department of Labor. Representative Schultz.
I'd rather hear what you have to say. I appreciate this discussion very much. I just want to clarify a couple things, and I'm happy that I forgot more that I was going to say, because I've spoken a lot. But to answer Representative Adjutant's question about why does this system exist, there are so many articles on this, so all you need to do is Google the phrase Jim Crow and subminimum, and you will get a slew of well-documented, well-substantiated accounts of why. And it is from the post-slavery era, and how do we bring all these folks who weren't getting paid and doing work that they felt needed to be done as slaves and not pay them. Well, we will make them dependent on, if they are well-behaved and nice, then their whole wages will be based on their tips. Tips were already a custom here anyway, as they were in Europe and other places, but their entire pay at that point was zero officially, and they literally, in a variety of jobs, famously as the Pullman company, the train company, in various roles, and in lots of restaurants, especially in the South. At some point, I haven't memorized what year, they thought, well, you know, maybe we should pay something. And so at that point, I believe it is in the last 100 years, the decision was made that paying zero was ridiculous. So that's good. But then they made the subminimum wage category for that. Maybe there had been subminimum wage categories already for workers who with disabilities. I don't know the history of that. But certainly for tipped wage workers, that was the history. And it still means that their pay is dependent on the grace and kindness or feasibility of their customers. And I didn't even get into the issues that raises with sexual harassment, because that has happened to some tipped wage workers here in New Hampshire, and a lot of other problems. But most servers get a paycheck that still says zero. And so from the slavery days to today, New Hampshire's only gone from $0 to $3.27. And while the law, I appreciate the clarification on the law of what and how people are paid, the easiest way to fix all of these confusions would be to just get rid of it and pay people the same way we pay them everywhere else. Not to get rid of tips. I would say $15 plus tips on top. But for the purpose of this bill, it would be $7.25 plus tips. And this discussion is so good, it also would be great as an interim study.
Would anyone else like to speak? All right, first off, in answer to your question, Representative Adigent, I suggest you talk to your congressional delegation and do something in Washington and get rid of the sub-minimum wage is a good start. And then we can tackle that here. Secondly, I figured this question would come up about Dos Amigos and this. This was a federal DOL investigation in Vine. Their laws are different from ours. That what they do is not illegal in New Hampshire. I was one of the co-authors of the new tipping bill with former Representative Murphy and Representative Simmons. Believe it or not, we sat down in a bar with a couple beers and we figured out the new tipping laws because our tipping laws were so out of date. And it came up because, you know, a bar has a spittoon, if you will, or some kind of a jar behind, and the bartenders all put their tips in at the end of the night and then give them out. That was illegal 5 years ago, 6 years ago. So we changed the law to allow for tip pooling and tip sharing. The number one thing in New Hampshire, which has always been adhered to, is tips are owned by the employees, never by the employers. Period, end of story, don't even bring it up. Okay? However, with the new law that we did change, you can have an agreement, if you want, amongst the employees, if they choose to say, look, we will give the waitress will give a certain amount of money for the busboy or the person that sits you down. I can't think of it right now. Hostess or whatever. So that is allowed. So there is some of those things that are allowed. But when it comes to this Dos Amigos, understand, if you ever been there, I love the place. You start here, you order, you go down, you watch them make it, and then it's there, and there's a tip jar. And the managers work just as hard right next to the employees. And they felt that they were following the law, which they were, according to New Hampshire. But apparently we have some disagreements with the feds on that. So just want to clarify what that situation. I asked Rudy Ogden, Assistant Commissioner Ogden, why this came about. He had not heard from the feds about this and why the investigation was brought forth. But it was not brought forth by the state of New Hampshire. So I just want to clarify some of those things. Did I get the tipping law correct?
Yes, there is some confusion with the reallocation of tips for certain positions, but the New Hampshire law is what we abide by.
Because believe it or not, an employer came in front of us and sat in front of the committee because they were fining the Department of Labor for, again, having that one container behind the bar where all the bartenders, a very busy place, would take all the tips and put it in at the end of the night, share it. They got fined. That was against the law. Well, that was being done in every single establishment in New Hampshire at the time. So since then, I don't believe there's been any issues. So that being said, that's all I have just to say regarding all the things that were either asked or brought up. Representative Cahill.
Yes, thank you, Mr. Chair. That just raises a question in my mind. And I understand the managers are working hard and the hostess and everything. It's customary to tip out. But are they working for tipped wages or something beyond that? The people who are, as far as federal law, inappropriately taking a share of the tips?
Again, I don't know federal law as well as I know New Hampshire law, but according to what we did, if the agreement was made with the employees to do that, and those managers were working right with them, and they agreed to that, that is legal in that would have been legal in New Hampshire. I don't know all the specifics of the federal case. I just know what we all read in the newspaper. Okay, Representative Huff.
Thank you, Mr. Chair. In the interest to Representative Sullivan, would it be appropriate to move the previous questions? Because I'm sure we'll have this debate more than a million more times.
I would ask you to hold that motion at this point. Are we all, has everyone spoken who would like to speak? What are we looking at? Josh, Representative Adigent, and then we'll close it up. Okay, thank you.
Thank you, Mr. Chairman. I just want to clarify for the record that the question that I asked was facetious.
Oh, I'm sorry. I thought you.
No. I couldn't square in my head how it made sense to dig a trench at 327 when the actual battle line is at 725. That was the kind of open-ended question there, but understood, and thank you.
I couldn't see through your monarch's mask, the smile on your face that you were giving me. Seeing that we have no other hands, very good debate. There is a motion on the floor. Unless it's going to be withdrawn, the motion on the floor is inexpedient to legislate. Seeing no other hands, seeing no other motions. Mr. Clerk, please call the roll.
Seaworth.
Yes.
Avalani. Yes. Callum.
Yes.
Mackey, yes. Love.
Yes.
Warden.
Yes.
Turcott.
Yes.
Prout.
Yes.
Boyd.
Yes.
Huff.
Yes.
Sullivan. No. Susie. No. Schultz.
No.
Cahill. No. Fellows.
No.
Schmidt.
No.
Toomey. No. Bouchard. No. Adjutant. No. Mandeville.
No.
Infantine.
Yes.
11-10.
No. No. I'd like to.
Do we know who's going to make the minority report?
I'm sure. Unless he knows right now, Representative Sullivan will let me know. Okay.
Is I supposed to write down what that'll be? Is it OTP?
1472.
Okay.
Next bill, House Bill 1472, prohibiting anti-union activities, and I would like to recognize Representative Huff for a motion.
Thank you, Mr. Chairman. I move that we render this ITL. Thank you.
Motion on the floor is inexpedient to legislate on House Bill 1472. It is seconded by Representative Avalani. The motion has been made and seconded. Representative Huff, you are recognized to speak about your motion.
Thank you, Mr. Chair. This bill would prohibit anti-union activities by employers. Although I believe that the authors have a good heart as to trying to keep fair, the reality is an employer is more than free to express his opinion as to how he would like to run his business, and to prohibit his First Amendment right of free speech or freedom to associate or to try and make a living, it shouldn't be allowed by government. So I ask that we ITL this bill. Thank you.
Thank you. Representative Bouchard, you're recognized to speak.
Thank you, Mr. Chairman. And in order to respond to Representative Huff's statement, I would like to agree with him that employers have employers have their right to their free speech. However, I am going to support this bill because it will eliminate employers requiring employees to attend anti-union videos. And I believe that's the crux of this bill, is to eliminate that. Thank you.
Thank you. Representative Adjutant, then Toomey.
Thank you, Mr. Chairman. Representative Huff is correct in that the intention of this bill is to level the playing field. Very often, and I've worked for several companies that have done this, show up the first day, you're hit with that video where very clearly people who've never worked for that company and are very obviously actors are telling you about how unions are terrible and they'll steal all your money, and there's something about being on the clock during those meetings that really enforces that to an employee. Really just want to make sure this is fair. I really just want to make sure the level playing field exists. I think this is a good bill. I would definitely support an ought to pass motion, and I hope the ITL fails so we can do that. I don't have as much more to say on that.
Thank you, Representative Toomey.
Yeah, this has three components to it, and I kind of wish it didn't. You know, one, it's an employer can't lock out employees. They would have to allow striking employees to come back to work. And then the other one has to do with forced attendance meetings relative to having a union. I'll just limit my discussion to the last. You know, I think it's been said before today, you know, it's a good idea to keep your proposals simple. But having said that, what happens very often if there's discussion of having a union, all of a sudden management brings in paid consultants and they hold meetings and employees are required to go to those meetings, and in fact they're coerced to listen. And first of all, if people decide or want to decide whether they want to, as a group, bargain individually or they want to bargain as a group, that's their business. It's not the employer's business. And so they're intervening into a process that should be handled solely by the employees. And so the employer, if they notice that employees refuse to go to those meetings, they can fire that employee. They have the ability to hire, fire, promote, demote, transfer, put letters in people's files, and they do that when people try to organize. And so, you know, if an employer wants to give employees their opinion about whether there should be a union or not, they can send a letter to employees and have the employees look at the pros and cons of it. But when they bring them into a meeting to coerce them, intimidate them in a process that should be handled solely by the employees themselves, I think that's wrong. Thank you.
Thank you, Mr. Chairman. Just responding to a few comments and a couple points. Currently, it appears that this would be an attempt to add on to or rewrite portions of the National Labor Relations Act or even the Railway Labor Act. We have things called collective bargaining agreements that if this kind of, these are big enough issues, you could even, I suppose, get those into your collective bargaining agreements. Being forced to watch this video or that video, I can tell you annually, on an annual basis, I have to sit through some woke presentations in my annual training that I'd much not prefer to sit through. And the last thing point I would make is this bill is prohibiting anti-union activities by employers. Are we going to have a companion bill that's going to be prohibiting anti-employer activities by labor unions? I am in favor of the ITL motion. Thank you.
Thank you. Representative Huff?
Thank you. I just wanted to make one small point off of what our honorable member from Hillsborough said. He was talking about the employers, and he said it's not their business. Yes, it is. Thank you.
You've heard the expression, the system isn't very good, but it's the best one we have. There's no one better one that has been devised. I look at this in the same thing when it comes to employees establishing a collective bargaining and creating a union. You're right, Representative Toomey. Some of the things that go on when a company is looking at having their employees organized are despicable. But neither one has clean hands. Whether it's videos brought by management, showing up to employees' doors to convince them issues with card checks, all these other things that go on. And it's not a great system. And some of the things that go on, I know some of you are too young for this, famous movie Norma Ray, and some of the things that go on, that have gone on. And both parties could do it better, no doubt. And a lot of these things shouldn't happen. I would love to have seen these for both groups be more equal. Both parties have to do this. Both parties have to adhere to that. There are certain rules with NLRB has certain rules and such and how you go about this, but I just think this is one-sided, and you have to look at both sides. And if you're going to set a law requiring employer not do this, then you have to have an equal law that says the organizer can't do that. Representative Sullivan, then Representative Schultz.
I think it's important to keep in mind that there's a very distinct power differential between individual employees and their employer. And in the organizing process, what you have is a group of individuals who are trying to figure out if they want to act collectively. But before they actually have that election, they are at a distinct power disadvantage to the employer. And issues like this are addressed by this bill are important to maintain that or to protect those employees from a hostile employer. And basically, it was mentioned that perhaps these issues can be placed in a collective bargaining agreement. Not if you don't have one yet. You've got to have a bargaining unit before you can have a collective bargaining agreement. And there are companies out there that we've all heard about that are working really hard to make sure, and there are companies that will close down facilities rather than allow them to unionize. And so it is a very hostile environment for unions these days, which is why legislation like this is appropriate.
I have a couple. Representative Schultz, Love, and Turcotte.
Thank you, Mr. Chair. I just want to briefly mention the fact that, especially since the Reagan era and what happened between Reagan and the air traffic controllers, began a trend that hasn't stopped, and that is to severely eroding the rights of workers to organize and unite, which, by the way, is on the list of human rights, what every human should be able to do. In this case, every worker should be able to do, collectively organize. But I think we have gone so far astray on this. And it correlates to the decline of the middle class and the difficulty for younger generations to own a home, pay for student loans, etc. I think union membership in this country is definitely more than half of what it was when I became aware. And it's really been hurtful. And you can see this in, I love talking about anything woke. It's always an interesting discussion. But we thought, woke companies, Amazon and Starbucks, who have targeted especially liberal-leaning humans to be their customers, they have been actively doing these tactics. And to the detriment of their workers. Because I don't believe, for the most part, that any union is quote unquote against the company. If they were, they wouldn't do a very good job as workers and representing those workers. I think that what it is for the power differential to be able to listen to, and it's not always about pay or benefits, it's often about little things that maybe management hasn't thought about. But I believe this type of bill returns to our society what we lost over the last 35, 40 years, and it's overdue. Thank you, Mr. Chair.
Thank you. Representative Love, followed by Turcott.
Thank you, Mr. Chair. Just a little bit of history. I was brought up in a union home. You know, my dad was a Teamster. My mother was a past president of one of the locals of the IBEW. My grandfather's a charter member of Teamster Local 25. I joined the Teamsters in 1974. I'm currently on withdrawal from Local 633. I've also been a business owner and an employer. And, you know, to reiterate what what Representative Huff said, you know, as the employer, if I'm paying you and I want you to watch a video, I'm not asking you to do anything dangerous. Go watch that video. You know, it's like one time I was on strike. I was working for a company, and what goes unsaid a lot around here. You know, I was over my grandfather's house, and you know, I'm telling him we're going to get this, and we're going to do this, and we're going to get it. And he sat there and he started waving his finger at me. He says, "Wait a minute. He says, remember one thing: if the boss isn't making money, nobody's making money." And that gets lost, you know, in union negotiations and stuff. You know, we've got to always remember that. You know, nobody wants the doors closing. That's it. Thanks.
Thank you. Representative Turcott.
Thank you, Mr. Chairman. In response to Representative Sullivan's points, he was making a lot of points about organizing. I would point out this bill itself, though, talks about, in Section 1, it talks about an employee participating in a strike. The second one is participating in a strike to lock out, suspend, or otherwise withhold employment. Those all speak to incumbent union members who are already covered by collective bargaining agreement. The only one that you could maybe even relate to organizing is the second paragraph down on line 13, but nowhere in this bill does it talk about organization or organizing a union. And I will go back to, especially when it comes to collective bargaining agreements and organizing, that in fact the NLRB and the RLA are very, have a lot of information and a lot of what's the word I'm looking for, already contains a lot of the same information or ideas that this bill is trying to put into it. So again, I rise in favor of the ITAL.
Seeing no additional hands, the motion's on the floor. If any experience of legislature has been seconded and we've had appropriate discussion. Mr. Clerk, please call the roll.
Seaworth.
Yes.
Avaloni. Yes. Callum.
Yes.
Mackey, yes. Love.
Yes.
Warden. Yes. Turcott.
Yes.
Prout.
Yes.
Boyd.
Yes.
Huff.
Yes.
Sullivan.
No.
Susie. Rudy.
No.
I'm sorry. I'm getting
Schultz.
I ran out of my sheets. I corrected. Yes. Cahill.
No.
Fellows.
No.
Schmidt.
No.
Toomey. No. Bouchard. No. Adjutant. No. Mandible.
No.
Infantine.
Yes.
11-10.
Thank you. I'm going to skip to would be a quick bill and then a quick 10-minute break. House Bill 1569 FN.
Motion, Mr. Chairman.
Totally unemployed.
You looking at me again? Motion, find HB 1569 ITL.
Yes, thank you. Motions on the floor is ITL, seconded by Boyd?
Who made the motion?
Turcott.
Okay, all set.
The motion's been made and seconded. Representative Turcott, you may speak to your motion.
Thank you, Mr. Chairman. The prime sponsor of the bill, Representative Lamb, came to the committee and asked that we find this bill ITL.
Anyone else like to speak on the motion of ITL? Seeing none, the motion's been made, seconded, discussion has been had. Mr. Clerk, please call the roll.
Seaworth,
Yes.
Avalani. Callum,
Yes.
Mackey, yes. Love,
Yes.
Borden,
Yes.
Turcott,
Yes.
Trout,
Yes.
Boyd,
Yes.
Huff,
Yes.
Susie. I'm sorry, Sullivan.
Yes.
Susie. Schultz,
Yes.
Cahill,
Yes.
Fellows,
Yes.
Schmidt,
Yes.
Toomey. Bouchard. Adjutant. Manaville,
Yes.
Infantine,
Yes.
21-0.
All right, consent agenda, unless, consent, objection. All right, we're back in, we're going to take a 10-minute drink and bathroom break. And then we'll go back to our last bill of the day. John, you're talking a lot today, bud. Sorry, thank you. Call the executive session back into order. We're, the last bill on the docket today is House Bill 1514 FN. I recognize Representative Cahill for a motion.
Thank you, Mr. Chair. I would like to offer Amendment 2022-0787H.
Seconded by Representative Toomey. Motion's been made and seconded. Representative Cahill, you're recognized to speak in your motion.
Thank you, Mr. Chair. This is a bill we've talked about a bit before, and I think the issues here, this is pruned down to just two instances where I think many of us might agree that the employees who had earned their time lost it through no fault of their own, through actions for which they had no control, no opportunity to make a difference in this, no opportunity to use the time before their employment terminated. And in one case, actually, they continued working just for a different company on the very same job, something that doesn't normally happen. And I think the vast majority of cases in that situation, what's done is the previous employer makes an arrangement with the new employer to accept the employees, not only the employees, the trained workers, but their vacation time, their earned time, PTO, whatever the term is. That's what's normally done. It's not required under New Hampshire law. And when it doesn't happen, what can happen is people lose whatever they had earned. It just suddenly vanishes from their pay stub, and they're starting from scratch. There was a discussion with Deputy Ogden at our hearing, and that the department has a means of going after these companies, but that's only if their policy had been stated that they do pay or transfer the time. When the policy says at termination, the term, that nothing is paid out, then that's the prevailing, that's the ruling. So in the case of I think there were 5 people from one place who did go through the process. They lost. They had their claims were denied because of this situation. So this bill, as amended, would require that the employer, when the company is sold, either transfer or pay out the time. That's what that does. The other situation covered by this is a permanent layoff, not a layoff, because that was a concern by the seasonal workers, but a permanent layoff, you're not going back. So and again, you have time that you've earned, and all of a sudden, today's your last day, whatever you have would be paid to you because you earned it. And you didn't have an opportunity, the policy may have been, obviously, if today's your last day, I can't say, well, let me take my vacation and I'll come back and work another week or two. That's not an option. So this, I think in the interest of fairness, we would pass this bill so that at least these two situations would be covered. There was additional language that we talked about before from our former member, Herschel Nunez, who detailed a fairly common practice where if the employee leaves in good standing, has been a good employee, and gives the employer notice that they're leaving, they also don't lose. But that's not in this bill. That's not in this amendment. So I request that you pass this, remembering that the people who are affected negatively are our constituents as well as the business owners. So I urge you to ought to pass on the amendment and the subsequent bill.
Thank you. Anyone else like to speak on the amendment for Representative Sullivan?
Might be a little premature on this, but I guess Representative Cahill's been working on this for a long time, and he's continually compromised, adjusted, amended, and tried to make this bill workable for the parties concerned. And I, for one, think this amendment gets us there. And finally, we should be able to move on this issue and take care of some folks who feel they've earned something, then find out that it's gone. So I want to commend Representative Cahill and support this amendment. Thank you.
Motion on the table has been made and seconded for the amendment. There's discussion has been had. Mr. Clerk, please call the roll.
Seaworth,
No.
Avaloni. No. Callum,
No.
Mackey, no. Love,
No.
Warden,
No.
Turcott,
No.
Kraut,
No.
Boyd,
No.
Huff,
No.
Sullivan,
Yes.
Susie. Schultz,
Yes.
Cahill. Yes. Fellows,
Yes.
Schmidt,
Yes.
Toomey. Bouchard. Adjutant. Maniville,
Yes.
Infantine.
Yes.
Amendment passes on 11-10.
Is there a question, Donnie?
They're discussing that was the amendment that passed.
There's the amendment. The amendment passed, the bill is open for further motion.
Mr. Chairman, I'd like to move O2PA.
Seconded by Representative Sullivan. You're recognized to speak to your motion. Representative Cahill.
Yes, thank you again, Mr. Chair. Again, the amendment is what I think our friend Mr. Gervais calls baby steps. And we hope that this will address some issues that people reasonably expect would not happen in the great state of New Hampshire in an employer-employee relationship. There are numerous cases that are claimed every year, every month with the Department of Labor. Not all of them are correct. I think few of them are under this circumstance, but these cases, I think we should address, and that's why I think I put the bill in, and I hope you will support it.
Representative Cahill, I thoroughly appreciate your dedication to this bill based on some of the circumstances you brought forth. You have been a gentleman, thoughtful, and just a stand-up guy to me and this committee when I was on it, and even when I was off, the things you've done. Representative Sullivan, you are correct that the concessions made over the years. As I explained to you, Mike, the issue comes down to line 13, where you feel that you call them earned time, I call them benefits, constitute wages due. And there were two members today who have spoken in this chamber that we don't need to tell businesses what to do. And each business is different. And each business decides that they're going to give vacation time, holiday time, sick time, or just some are just saying a certain block of hours, do with it what you want. But the reason many employers give benefits to their employees, such as vacation time or sick time, is because they want to be good to their employees, and give them a vacation because they come back refreshed. It's good for them. It's good for everybody. And frankly, it's the right thing to do, giving people vacation time. It's the right thing to do to give people sick time. And I'm all in favor of that. But it doesn't mean that it's equal to a cash out payment. And that's where we have this fundamental disagreement. I give someone 2 weeks vacation at the beginning of the year, and then they quit the first week of the year and they want 2 weeks paid vacation. Or they keep it going 3 or 4 years, sick time or vacation, and then leave for a number of reasons, good, bad, or indifferent, and they want that what I consider a benefit and you consider earned time a cash payment for. And that's kind of where we disagree. These circumstances you talk about, my apologies. The circumstances that you talked about and that we know well are wrong when one company was sold to another and they didn't bring those benefits over, okay? And those things, you know, hopefully we have the laws for you, or those can be tweaked. But again, I can commend you, Michael, for just being an absolute stand-up guy on how you've addressed this and how you've treated this committee with these things. And the reason why, on two separate occasions, I have wanted you to have that opportunity to make your motion and submit your amendments. When I knew that probably the votes may not be there, because of how you just treated this committee and everyone. I just can't get over the cash out payment, and it's just too much for me. So it pains me to say I cannot support your amendment here, because I don't think we should be telling everyone, these businesses, what to do. As I said, repeating myself, a couple members of your party said today about not telling businesses what to do, and that's a really tough thing we have here in this committee. All right, it's trying to be consistent, and not trying to tell people what to do, but maintaining the safety of our employees and such. So I apologize, Michael. I cannot, Representative, I cannot support your amendment, but I sure support your dedication, tenacity, and gentlemanly. Toomey, Sullivan, and then Michael. I'll let you. Sorry, I shouldn't be calling you by your first name. I apologize, Representative Cahill. But
Am I up?
yes.
All right. If you make a deal, you live up to the deal. It's as simple as that. If you don't want the government to get involved with the employee-employer relationship, live up to your deal. Make it clear. There was a discussion of flexibility. The employer has all the flexibility in the world. They can, if they decide to give their employees a vacation, possibly because their competitors are giving their employees a vacation, if they decide to do that, they can set up all kinds of restrictions and parameters on it. We talked about it before. You can have use it or lose it. You can have a stipulation that you have to work for a full year before you can take the vacation. You can do all kinds of things. So if you don't want the government to get involved between the employer and the employee, live up to your deal. Make your deal clear. And you know, that's what I think the sponsor of this bill is trying to accomplish. Thank you.
Representative Sullivan.
Mr. Chairman, I was listening to you very carefully, and I may have misunderstood, but I just want to be sure that this is being interpreted correctly. As I read this, there are only two circumstances in which an employer would be required to pay out the unused vacation. One would be a permanent layoff, and the second would be a change of ownership. I thought I was hearing you talk about a cash out when someone just decided to leave. Representative Cahill's taken that out of the bill. So it's when something happens that's beyond the control of the employee that the employer would be required to pay out the unused vacation time. Just want to make sure that's clear. Thank you.
Thank you. Representative Cahill. And then Turcott.
Thank you. Oops. Thank you, Mr. Chairman. And I do appreciate the many years you and I have spent together on this committee. It's been very, I often tell our members on the first day, this is the best committee, and I stand by that. Regarding the cash out, this again, the proration that happens if you say you've got 2 weeks and the person quits 1 week into the job, they have no claim on 2 weeks because whatever you said they could have would be prorated. So the employer is protected against that sort of outsized loss. And as my colleague, Mr. Sullivan, has indicated, this is very limited to only 2 circumstances. So this is very small, a baby step, if I may. But I think it's the right thing to do. And I wish it could be retroactive if I ever get this passed, but I can't get it retroactive because we can't do that. But maybe I'll launch a GoFundMe for those people that were victims in this, and I know you'd all like to contribute. Thank you, Mr. Chair.
Thank you, Representative Turcott, followed by Schultz.
Thank you, Mr. Chairman. I would also echo the chairman's words to Representative Cahill on his diligence and work on this issue. I will have to say, though, that unfortunately, the length of time put into it and the diligence you have put in, unfortunately, is not, for me, a reason to pass it when we still have the basic, I guess you call it a philosophical issue on this. I tend to put bills like this into my personal life, and recently myself and many of our pilots ran into a situation where we faced possible termination due to, not getting accepting the vaccine mandate. And in that policy, if that would have happened, our contract allows us to build up sick bank to an extraordinarily large amount of time. Had we been terminated, all of that would have gone out the window, and I can assure you it was a substantial amount of money. But having said that, that's part of our contract. We should have the gumption while we're doing our next negotiation to ensure that if we are terminated or if we leave or whatever, that sick time will be paid out. Because I would agree with you in a situation like that, if I should get paid, but I also realize it's a function of our contract, and as it is now, we don't. I mean, it's just the way it is. We've talked about this many times. The policies that a business and an employer and an employee, the policies should be laid out. If they don't, that's a joint problem between the employer and employee. I, as an employee, if I'm going to go get hired someplace, I'm going to want to know what my benefits are, what the issues are, what the policy manual is, and it should be the same for the employer. Lastly, I'm going to say that although I truly love the input we get from Mr. Duvet and Mr. Berkey and Mr. Abbott and the others who frequently come to our committees here, we had an individual that was not a lobbyist, registered lobbyist, come and speak to us at this last hearing, and her name was Allison something or other. I don't even remember. She was a private business owner, in HR consulting, and she did one of the best testimonies I've ever heard here. She was convincing, she was concise, it was excellent, she was on point. She said so many good things, I didn't write them all down, but the one note I did make on it was, I think she finished her testimony by saying, I see this as making law for bad employees at the expense of the good. Now, again, I don't remember, I'm taking it out of context here probably a little bit, but between the lobbyist opposition, we've had this bill many times. I think we've gone over, again, many times the issues that are with it. I unfortunately cannot support ought to pass on this.
Seaworth? Oh, I'm sorry, I apologize. I'd already called Schultz. Go ahead. Go ahead.
Thank you, Mr. Chair. I would have been fine either way, but just 2 quick points. It is common practice now that paid time off and sick leave, but now many places pull them together, but some don't, is earned over time. So there wouldn't be, especially the distinction of there's really only 2 cases that this bill would apply to anyway. That wouldn't be, a bank of 2 weeks at the beginning. It just wouldn't be. That's just not the custom, simply for the reason that you stated, that if I understood you correctly, that there wouldn't just be a big bank of weeks you earn in a new job, unless maybe you're a high executive, maybe that works. But typically it is always earned like at a certain rate. So many, 1 day of vacation earned for every 30 days, or whatever that policy is. That is the common practice in private business. That's it. Thank you.
Representative Seaworth?
Thank you, Mr. Chairman. I'm a little concerned. I hear 2 things being said at once, and they can't both be true. One is the assertion that this only applies to 2 cases, the permanent layoff and the transfer of business ownership. Then the other thing, and I just heard it repeated, is that as a matter of fact, once you accrue vacation time on a prorated basis, that's cash in your pocket should you decide to leave the company at that point. So the 2, yes, if I'm owed 2 weeks for the year and I leave after 6 months, I don't get the full 2 weeks, but this bill says I should get 1 week, because that's 6 months worth of my 2 weeks. And it clearly says that 17 through 24 talk about those 2 special cases, but outside of that paragraph, in a different section, there's lines 12 through 14, which say paid time off, vacation time, earned time, sorry, I'm reading that out of order, shall be considered compensation and therefore constitute wages due. That's not contingent upon one of these other 2 situations. So people have tried to correct the chairman and say he misunderstood lines 12 through 14, and then I heard it restated that, yes, as a matter of fact, that means just what it looks like it means, that once you receive accrued time, that's as good as cash in the bank should you become separated. So it bothers me that we're going into a vote where we're saying the language that's before us means 2 entirely different things. It obviously is intended to mean one or the other, and it's obviously written one way or the other. And personally, I agree with everything the chairman said about it. I could be corrected if I'm entirely mistaken, though. Thank you.
Representative Manaville and then Cahill.
Thank you. Thank you, Mr. Chairman. Just quickly to touch on the point just raised, the way I read this bill is that in line 12 it says, for purposes of this section, and therefore the definition of vacation time, et cetera, as wages due is applicable to the rest of the section, and that does relate to the specific conditions that are addressed. Mr. Chairman, you mentioned several people having described intervening between an employer and employee as a bad idea, and I might have been one of them you were thinking of when we were talking about the non-competes. And that in the question of a non-compete, you have typically a specifically negotiated deal between sophisticated parties. Here, we're talking about something that's usually a non-negotiated, a standard practice, and there's the question of what is understood between the parties. It's true this just relates to 2 specific areas, but my concern is that it relates to an area where an employee really doesn't understand the loss that he or she will sustain if and when one of these two things happens. It's not a negotiated for thing, it's an unperceived thing. And that's the inequity that this bill seeks to address, and that's why I'll support it.
Representative Cahill, followed by Seward. Seward, did you have your hand up again? No.
Thank you, Mr. Chairman. What he said. And I'll add that, you know, I recent study, 54% of workers leave behind vacation time. And it's either they don't use what they're allotted and they continue employed, or they leave, even though they're encouraged to use the time because it's good for them, it's good for the company to be refreshed and everything. But again, this does apply to only these two situations where I believe they're unanticipated. You know, the employer may have an idea that he's going to sell the company, you know, in a year or two, but he certainly doesn't tell the employee that when they walk in. The employee would not peruse the entire handbook. Basically, you're listening to what's the pay, what's the hours, how much of the health insurance do I have to cover. You're not asking about what happens. It's not an antenuptial agreement that we're considering, and I know it's not very romantic if you were saying what happens when we break up. You know, do I get to keep this and you get to keep that? So it is, again, very, very limited, and all you have claim to is what you've earned, and I know that's a little philosophical difference about whether you earned it or it was a gift, but it's pretty clear that people earn their vacation time and that it should belong to them, at least under these circumstances when they leave. Thank you, Mr. Chair.
Representative Fellows.
Thank you, Mr. Chair. If you had asked me before today if things like this ever happened, that people were laid off or whatever, and they thought that they had vacation days accumulated that they were going to get paid for and they weren't, I would have been astonished. I think this bill, that just goes on, just floors me. So to me, this bill just looks like a truth in hiring bill. So when somebody's hired, this bill requires that the employer write down exactly the conditions that he wants to have related to accumulated vacation in 6 days, and just spell it all out. It doesn't require them to do anything specific. It doesn't require them to give a certain number of days. It doesn't require a maximum number of accrued days. They can write whatever policy they want. They just need to write it down and give it to the employee so that they know what they're in for. So in terms of your example, you hire somebody and you tell them they have 2 weeks of vacation a year. It should be spelled out if they earn that right from the beginning and can take it all in the beginning, or if they need to wait a month and take, you know, just part of it. If they accrue a day a week or 1 day a month vacation, it just needs to be spelled out. It doesn't prevent them from doing anything. They just need to spell it out so the employee knows what they're getting into. That's my opinion, from someone who has no experience with your committee. Thank you.
I appreciate you at least taking the time to read it and make some comments. Thank you. Representative Cahill.
Yes, I'd like to speak, but only after the gentleman with the pen has been recognized.
I apologize. I don't look to my right. I apologize. Representative Davalani.
Thank you, Mr. Chairman. Lines 12 through 14 are of particular interest to business owners. We're redefining what earned time, vacation time, and paid time off would be considered compensation and therefore constitute wages due. While it looks simple on the front, Section 44 of 275, payment of wages, the first sentence under 275-44, whenever an employer discharges an employee, the employer shall pay the employee's wages in full within 72 hours. If we're taking earned time, vacation time, paid time off, and making it wages due, where is the benefit to the employer if we're taking away the sick time as well for being considered as wages due. Maybe they have a vacation time, use it or lose it policy, but they get to bank their sick time. And if they're separated, their wages due becomes null and void if they have a sick bank. Just want to make sure that we're talking about the same thing when they equate vacation pay with wages due. Does that make sense, Mr. Chairman? Thank you.
One last comment for Representative
Yeah,
Cahill.
thank you, Mr.
Oh,
Chairman. And to Representative Avalani, the sick days are not considered wages due. They shall not be considered wages due. So you would only pay, and again, only under the circumstances if you unfortunately decided to leave the restaurant business and sold your business and did not transfer the hours that your employees had earned, you would be required to pay them, but not for the sick days. If you use PTO, instead of separating them into different banks, then I guess in that situation you would. But that's a decision that you could take prior to that time. I wanted to correct the record for our colleagues sitting in today, because the bill does not just require you to spell it out, although there were some good business practices up in the first section. It also requires that under these circumstances, a layoff or transfer or sale of the business, then you would pay the time that the employee has earned on their pay stub. That's the main focus of the bill. Thank you, Mr. Chair. OTPA.
Representative Schultz. Schmidt, sorry, Representative Schmidt. I've been saying Schultz all day. Representative Schmidt.
Thank you, Mr. Chairman. Every big company I've ever worked for before has a spreadsheet, and on the spreadsheet, they put down what you've earned. It is part of what they manage, all their books. They just make sure if Section 1 here is followed, your vacation time, your paid time off, your earned time off would be on that spreadsheet. That is part of their responsibility to maintain their business. I think this is a great idea, especially section number 1, where you're asking businesses, just to be clear, it shouldn't cause any extra trouble. We're not asking anything of a business that they shouldn't normally do, but there are some that don't. And it would be very, very nice to be able to set this into law. Thank you.
There's a motion on the floor on to pass with amendment. It's been made, seconded, and we've had discussion. Mr. Clerk, please call the roll.
Seaworth.
No.
Avalani. No. Callum.
No.
Mackey, no. Love.
No.
Warden.
No.
Turcott.
No.
Prout.
No.
Boyd.
No.
Huff.
No.
Sullivan.
Yes.
Susie. Yes. Baruti.
Yes.
Oh, I'm sorry. Schultz. Cahill.
Yes.
Fellows.
Yes.
Schmidt.
Yes.
Toomey. Yes. Bouchard. Yes. Adjutant. Yes. Mandible.
Yes.
Infantine. No. No. Okay. 11-10.
Motion fails. The bill is open for additional motion. Appropriate would be interim study or inexpedient to legislate. Representative Turcott.
Thank you, Mr. Chairman. I move HB 1514 with amended 1514 ITL.
Motion by Representative Turcott is bill is amended ITL. Seconded by Representative Warden. Would you like to speak to your motion, sir?
Thank you, Mr. Chairman. Everything we've already said, I think I'm good on that. Thank you.
Seeing no other comments, the motion on the floor is inexpedient to legislate. Clerk, please call the roll.
Seaworth.
Yes.
Avalani. Yes. Callum.
Yes.
Mackey, yes. Love,
Yes.
Warden,
Yes.
Turcott,
Yes.
Kraut,
Yes.
Boyd,
Yes.
Huff,
Yes.
Sullivan,
No.
Susie, Schultz,
No.
Cahill,
No.
Fellows,
No.
Schmidt,
No.
Toomey, Bouchard, Edgerton, Manville,
No.
Infantine,
Yes.
11-10.
That concludes the items we have on today's executive session. We have 4 more bills to exec. We're waiting on some amendments. I would have liked to have met on the 10th, which is the last day we had to process our bills. We are not allowed to do that because that is a House session, so we'll be meeting Wednesday, the 9th. I will announce the date, the time. It'll probably be, try to do a morning, so we're done between like 9:30 and 12 on the 9th. If there's no other questions from the chair, thank you very much for your diligence and professionalism today. We'll see you folks soon. The hearing, executive session is closed.
I don't know which is more work, doing this or doing all the note taking on the hearings. Different anyways. If I'd asked if I wanted a job, I probably would have said no.
Well, I think your notes, you do so much better than anybody else. You have to understand, no one else does the notes.
I know. That's why I was talking to a
So
person
you
who's
can
clerk.
feel free to dumb it down a bit.
I know. But see, my writing's unreadable. That's why I have to type it.
No, what I mean is you don't have to type so much.
Oh, yeah, I know.
You type really diligent.